Ever been in a situation, maybe you saw something unfold in public and you just thought, what's the legal line here? Like, what power do the authorities actually have in a moment of crisis? And maybe more importantly, what are my rights? It's a question that really touches on our deepest sense of personal freedom and, safety. Today, we're taking a deep dive into something absolutely fundamental to our legal system, the power of arrest. We're cracking open Chapter 5 of the Bharatiya Nagrik Suraksha Sanhita 2023, the BNSS. That's India's new criminal procedure code, essentially the rule book for police and courts. This chapter, titled Arrest of Persons, details how, when, and by whom an arrest can be made, and crucially, what safeguards are in place for you.
Yeah, and what's truly fascinating here, I think, is how this chapter intricately weaves together two sort of competing forces. On one hand, you have the state's inherent power to maintain order, apprehend suspected offenders. And on the other, every individual's fundamental, constitutionally protected right to liberty. It's a delicate, well, it's often a contentious balance. Our mission today is to unpack precisely how the BNSS tries to achieve it. We want to offer you clear, actionable insights and maybe some aha moments, without the overwhelming legal jargon.
So exactly. Whether you're prepping for a meeting, maybe catching up on developments in the field, or just, frankly, insanely curious about the mechanics of law, this deep dive is really custom-tailored for you. We'll aim to give you the shortcut to being well-informed, providing those surprising facts and memorable details that stick, so you leave feeling empowered and knowledgeable. So let's kick things off. Where do most initial police actions begin? I mean, when can a police officer actually make an arrest without needing to get a warrant from a magistrate first? This seems crucial for immediate intervention, especially in serious situations, right?
That's exactly right. Section 35 of the BNSS is really the bedrock of that police authority for immediate action. It carefully spells out the specific circumstances under which a police officer can lawfully make an arrest without a warrant. And importantly, this power isn't arbitrary at all. It's tied to some very strict criteria. The big one, and probably the most common ground you'll see for a warrantless arrest, is what's called a cognizable offense. Think of it as a serious crime, things like murder, severe assault, robbery. These are situations where the police can essentially leap into action and arrest someone without first asking a judge for permission. But even then, like I said, it's not arbitrary. It requires a reasonable complaint, credible information, or reasonable suspicion that a person has committed such an offense. It's about tangible indicators, not just a gut feeling.
Okay, so the police can't just act on a whim, but what does reasonable suspicion really boil down to in practice? Is it like needing some concrete evidence, or could it be just a really strong feeling?
It's definitely more than just a strong feeling, legally speaking. Let's take an example. Imagine a police officer receives credible information, maybe from a reliable informant, that Mr. A has just committed a severe assault, which is a cognizable offense. Under Section 35(1), that officer can immediately arrest Mr. A without needing a warrant. Now, the information doesn't need to be absolute proof at that stage, but it must be reliable enough, credible enough to form that reasonable suspicion.
Yeah.
This really transforms police action from, like you said, mere gut instinct into a legally defensible decision. It demands tangible reason before someone's liberty is touched. It's kind of like a gatekeeper, forcing police to build a mini case, however swift, before laying hands on someone. And beyond cognizable offenses, Section 35 lists several other key grounds. For instance, a police officer can arrest someone who is a proclaimed offender. That's someone officially declared an absconder, maybe in newspapers or police notices. So if police identify a person who's absconded after, say, serious financial frauds, they can arrest him without needing a fresh warrant for that specific encounter. Just being proclaimed is enough.
Okay, so the original warrant or proclamation still stands.
Exactly. Other grounds include finding someone in possession of stolen property, where there's also reasonable suspicion they committed an offense related to that property, or, quite directly, someone who obstructs a police officer while they're performing their duty, or someone who tries to escape from lawful custody. That's a direct interference. The section also covers armed forces deserters if there's reasonable suspicion someone is a deserter. And arrests based on a requisition from another police officer, provided, of course, that the original officer could have lawfully arrested without a warrant themselves. There's even a specific power related to breaching a bond given under the code, and a crucial link we'll touch on later, Section 39, which covers refusal to give name and residence for relatively minor offenses.
Right. So Section 35 lays out these very specific situations where swift action might be needed, but it always seems to circle back to that reasonableness standard. It feels less like a blunt instrument and more like a finely tuned tool for immediate response, but only when justified.
That's a great way to put it. Section 35 is absolutely essential because it tries to strike that balance between effective law enforcement, catching criminals quickly, and protecting individual liberty. Those phrases, reasonable complaint, credible information, reasonable suspicion, they aren't just legal fluffs. They're critical safeguards designed to prevent arbitrary arrests, to ensure police power isn't just unchecked. This section forms the legal basis for the vast majority of initial police interventions, allowing swift action where maybe waiting for a warrant could compromise public safety or allow evidence to disappear.
Okay, so the officer has the power under Section 35. They've decided an arrest is necessary. What happens next? What are the police supposed to do step by step? Because like you said, making the arrest is just the first step. How it's done must matter immensely for due process, protecting the arrested person.
Absolutely. And that's where Section 36 comes in. This is essentially the rule book for the arresting officer. It details not just if an arrest can be made, but how it must be conducted. This section lays down some very precise procedures and critical duties for the officer making the arrest. It's all about ensuring due process and safeguarding rights, which is, vital for maintaining the rule of law. First, there's the manner of arrest itself. How is it physically done? The section says it can be by actually touching or confining the body of the person, or even if the person submits to custody orally by word or action. But crucially, it emphasizes that reasonable force can only be used if the person resists the arrest or tries to evade it.
So no unnecessary force, that's clear.
Right. Next, and this is absolutely paramount, the officer has an absolute duty to immediately inform the arrested person of the specific grounds for their arrest, the full particulars of the offense. Just imagine being taken away and having no idea why. Section 36 fundamentally prevents that. It ensures transparency right from the very outset. You have a right to know exactly why your liberty is being curtailed. Then, if the offense is bailable, which generally covers less serious crimes where getting bail is considered a right, the officer must inform the arrested person of this right. They must tell them they're entitled to be released on bail, and importantly, that they should make arrangements for sureties if needed. Sureties are essentially people who guarantee your appearance in court, often by pledging money or property. Informing someone of this right can literally determine how long they spend in that initial detention.
That's huge. Knowing you can get bail makes a world of difference.
Definitely. Then there's the requirement for an arrest memo. The officer has a duty to prepare a detailed memorandum of the arrest memo at the time of the arrest. This memo isn't just a note. It must be attested by at least one witness. Ideally, this witness should be a member of the arrested person's family or a respectable person from the locality where the arrest is made. And, importantly, it needs to be countersigned by the arrested person themselves.
What's the point of the memo exactly? Accountability.
Exactly. It acts as a verifiable record of the arrest, detailing the time, the place, who witnessed it, the basic grounds. It significantly enhances transparency and accountability in the whole process. Another really critical duty is to inform a relative or friend. The officer must inform a friend, relative, or another person nominated by the arrested person as soon as practicable about the arrest and the specific place where they are being detained. This is such a vital safeguard against, secret detentions or people just disappearing into custody, things which historically have been precursors to abuse. It brings the arrest into the public domain, even if just to a small circle, and allows support systems, family, lawyers to kick in. And there are more duties. There's the duty to get the arrested person medically examined by a registered medical practitioner pretty much immediately after arrest. We'll dive deeper into that under Section 47. And, perhaps most importantly, the paramount duty to produce the arrested person before a magistrate without unnecessary delay. This usually means within 24 hours, and that 24 hours excludes the time needed for the journey from the place of arrest to the magistrate's court. We'll explore that 24-hour rule more under Section 58.
Wow, okay, so it really is a detailed step-by-step process. Let's try to walk through it. Say Mr. Khan's arrested for theft. Officer C needs to, physically touch or confine Mr. Khan, immediately tell him, you're under arrest for theft of valuables from XYZ residence.
Yeah.
Then ask him if he wants to inform a relative, like his wife or brother. Prepare that arrest memo, maybe get a neighbor to witness it, have Mr. Khan sign it, arrange for a medical exam soon after, and then make absolutely sure Mr. Khan is in front of a magistrate within that 24-hour window plus travel time. You can really see how each step builds on the previous one, creating this chain of safeguards, aiming for a procedurally correct and hopefully fair process.
Precisely. Section 36 is the bedrock of preventing arbitrary arrests, ensuring transparency, and protecting the fundamental rights and, frankly, the dignity of the person being arrested. And it's not just theoretical. Failure by the police to strictly follow these procedures can often be, and frequently is, a key area for legal challenges later on. That really highlights its crucial role in safeguarding due process. It underscores that the law isn't just concerned with catching suspected criminals, but very much with how that apprehension is carried out.
Okay, so with all these detailed duties laid out for the arresting officer in Section 36, who ultimately ensures that these rules are actually followed,
Yep.
who holds the police themselves accountable within their own system?
That's a great question, and Section 37 touches on this. It deals with the designated police officer. While Section 36 outlines the duties, Section 37 seems aimed at ensuring clarity and accountability regarding specific roles within the police force concerning arrests. It suggests that particular individuals, or perhaps units, are formally held responsible for making sure these legal procedures for arrest and detention are adhered to. For example, this could be the officer in charge of a police station, the SHO, or maybe the officer overseeing the lockup, or even a more senior officer like a deputy superintendent of police, DSP, responsible for overseeing all arrests in a specific area or ensuring compliance across the board.
Right, so it's like having a designated team lead or maybe a compliance officer whose job includes making sure everyone is playing by the rules set out in Section 36 and other related sections, ensuring those rights are truly upheld in practice.
Exactly. It sounds like a mechanism to reinforce the institutional commitment to due process. By formalizing accountability within the police structure, it makes it harder for responsibilities to just be shrugged off and provides a clear point of contact internally and perhaps externally for compliance with these critical arrest procedures.
Makes sense. Now, one of the most powerful rights we've touched on, and maybe the most crucial during investigation, is the right to legal representation. But how immediate is that right? Can it happen while the police are actually questioning you? This really gets into the heart of fairness during interrogation, doesn't it?
Oh, absolutely huge, E. Section 38 enshrines a fundamental right that acts as a critical safeguard against coercion and ensures your rights are protected even while you're in police custody. This is the right of an arrested person to meet an advocate of his choice during interrogation. Let's break that down. First, it's a right. A legally enforceable entitlement, not just something the police can grant or deny at their discretion. It flows directly from Article 22 of the Indian Constitution, which guarantees the right to consult and be defended by a legal practitioner of one's choice. And notice, of his choice. The individual has the autonomy to choose their own lawyer, which is vital for building trust and confidence in their legal representation. But the really critical phrase here is during interrogation. This means exactly what it says. While the police absolutely have the right and duty to interrogate a suspect, the arrested person has the corresponding right to have their advocate present while that questioning is happening.
Present, like right there in the room.
Well, the interpretation often is that the advocate can be present within earshot, close enough to see and hear what's going on, to observe the process, and to deter any illegal methods or coercion. They might not be allowed to sit right next to the accused and dictate answers, but their presence itself is the key. This significantly reduces the likelihood of police resorting to third-degree methods or other illegal means to extract confessions or information. It fundamentally safeguards against coercion. Your advocate can advise you on your rights during the interrogation, like the right to remain silent, the right not to incriminate yourself, promoting fairness in what can otherwise be a very intimidating situation with a stark power imbalance.
So let's take Mr. Sharma again. He's arrested on suspicion of fraud, taken to the police station for interrogation. Under Section 38, before they even start questioning him, or at any point during it, Mr. Sharma can say, "I want to meet my lawyer." The police must allow his chosen advocate to be present during that questioning. The advocate can observe, maybe interject if things go off track legally, advise Mr. Sharma on legal points, and ensure the questioning stays within legal bounds and doesn't become coercive. It sounds like a very practical, tangible legal shield against potential misconduct.
It really is. This statutory right, Section 38, directly reinforces that constitutional protection under Article 22. It's a vital human rights provision. It ensures a fairer process, acts as a powerful check on potential police misconduct, and ultimately contributes to the integrity of the entire justice system.
Okay, so you definitely have rights if you're arrested for a serious offense. But what about very minor offenses? Can someone just, refuse to identify themselves and simply walk away? I think we've all seen that kind of scene in movies, but what's the reality under the BNSS for, say, littering or something?
Yeah, the movie scene rarely matches reality. And no, you can't just walk away anonymously. Section 39 addresses this very specific scenario. Arrest on refusal to give name and residence. This section gives police a limited, specific power of arrest precisely for these situations. The conditions are quite precise. It applies when a person, in the presence of a police officer, has committed or is accused of committing a non-cognizable offense. Remember, that's a less serious crime where police generally cannot arrest without a warrant. But if that person then refuses to give their name and residence when asked by the officer or gives information the officer has reason to believe is false, then the officer can act. The purpose of this specific arrest is solely for ascertaining their true name or residence. It's a pragmatic provision. It ensures that even for minor infractions, the legal process can actually begin by establishing who the person is.
Right. So, back to my example. A police officer witnesses Mr. X throwing garbage in a public place. Likely a minor municipal offense, probably non-cognizable. The officer asks Mr. X for his name and address, but Mr. X refuses or gives a fake name. Under Section 39, the officer is empowered to arrest Mr. X without a warrant, but only for the purpose of finding out who he really is. Once Mr. X provides verifiable ID, say his Aadhaar card, he would typically be released on executing a bond to appear later if needed. So the message is, you can't just be an anonymous litterbug and expect to get away with it. It allows the process to start.
Exactly. And there are important safeguards built in here, too. Once the true identity is ascertained, the person must be released on executing that bond to appear before a magistrate if required. Crucially, if the true name and residence cannot be ascertained within 24 hours from the time of arrest, or if they fail to execute the required bond, they must be forwarded to the nearest magistrate having jurisdiction. This prevents indefinite detention just for what is essentially an identification issue. It's a pragmatic exception to the general rule about warrantless arrests for non-cognizable offenses, allowing police to overcome that practical difficulty, but it comes with those strict time limits and judicial oversight.
Okay, that makes sense. So far, we've really focused heavily on the powers and duties of the police. But what about the role of ordinary citizens, or even judicial authorities like magistrates, in actually making arrests? Do they have a part to play beyond just reporting a crime?
They certainly do. The power of arrest isn't exclusively held by the police.
Okay, this is where it gets really interesting for me. You're saying ordinary citizens, like you or me, actually have a limited power of arrest. That's the citizen's arrest idea, right? But I assume it's not for just anything, and it probably comes with some pretty strict responsibilities.
You're absolutely right on both counts. Section 40 covers this. Arrest by private person and procedure on such arrest. A private person, meaning any ordinary individual, not acting in an official capacity may arrest someone, but only under very specific and generally quite grave circumstances. There are two main situations. One, when a person commits a non-bailable and cognizable offense in their presence, or two, when the person they encounter is a proclaimed offender, someone officially declared an absconder. Now, that phrase, in their presence, is absolutely critical for the first situation. Mere suspicion or hearing about it later is not enough. The private citizen must have directly witnessed the commission of that serious offense. And notice the type of offense, non-bailable and cognizable. We're talking serious crimes here. Think murder, rape, grievous hurt, robbery, things that are both serious enough that bail isn't an automatic right, and serious enough that police could arrest without a warrant anyway. The law basically empowers citizens to act immediately only when a really serious crime is unfolding right in front of them or when they happen upon someone who's already officially on the run.
Okay, so let's picture it. Mr. Kumar is walking down the street and witnesses a brutal assault, clearly a non-bailable and cognizable offense happening right there. The assailant tries to run away. Under Section 40, Mr. Kumar, as a private person, is legally empowered to try and stop and arrest that assailant because the crime was committed in his presence.
Precisely. Or, another scenario, Missa Devi recognizes a person on the street from a police wanted poster, identifying them as a proclaimed offender. She, as a private person, could also attempt to arrest this individual. But, and this is the crucial procedure part, the private person cannot just hold the arrested individual indefinitely. They absolutely must make over the arrested person to a police officer or take them to the nearest police station without unnecessary delay. And the law is even more specific here, adding a time frame. This handover must happen within 6 hours of the arrest.
6 hours? Why such a short time frame?
That short time frame is a vital safeguard. It reflects the principle of citizen's arrest, recognizing immediate intervention might be necessary for serious crimes when police aren't instantly there. However, it simultaneously imposes a strict responsibility. A private person obviously doesn't have the legal training, the facilities, or the authority for lawful detention, so the prompt handover to legal authorities is absolutely key to prevent things sliding into vigilantism or potentially false or unlawful arrests. It's truly about empowerment with immediate accountability.
Got it. So, citizens have a role in extreme situations. What about those who administer justice more directly, the magistrates? Do they ever step out from behind the bench, so to speak, and make an arrest themselves?
Yes, they absolutely can. Section 41, arrest by magistrate, confirms this. It states that magistrates, and this includes both executive magistrates, like DMs or SDMs, and judicial magistrates, have the exceptional power to make arrests themselves or order someone else to make an arrest under certain conditions. It's quite a direct form of judicial intervention. The section outlines two distinct scenarios. First, if any offense is committed in the presence of a magistrate, whether executive or judicial, and importantly within his local jurisdiction. In that situation, the magistrate may himself arrest or order any person to arrest the offender. And once the arrest is made, the magistrate can immediately take steps to commit the offender to legal custody. This grants an immediate, on-the-spot power of arrest. The idea is that an officer entrusted with administering justice shouldn't have to be a helpless spectator if a crime happens right in front of them.
Wow, so if a judicial magistrate, first class, JMFC, is, say, walking through a public park within his assigned area and witnesses Mr. A openly committing a serious assault, that JMFC can immediately personally arrest Mr. A, or they could direct a nearby police constable or maybe even a civilian standing there to make the arrest and then order Mr. A into custody right away.
Exactly. The second scenario covered in Section 41 is slightly different. It allows any magistrate to, at any time, arrest or direct an arrest in their presence, within their local jurisdiction, of any person for whose arrest he is competent at the time and in the circumstances to issue a warrant. This covers situations where the magistrate doesn't necessarily witness the offense itself, but perhaps encounters someone they know they have the authority to issue an arrest warrant for. Maybe someone wanted in a case pending before them. It reinforces the magistrate's authority to enforce warrants directly when the person is right there, rather than having to wait for the police to find them. It highlights that the power of arrest isn't solely with the police. Judicial and executive officers also have a direct, immediate role to play in ensuring justice is served, particularly within their own purview.
Right. Speaking of special authorities and specific rules, members of our armed forces often operate under different conditions. Do the regular rules of arrest apply to them in the same way, especially when they're on duty?
That's a very important point. And no, the rules are different. This is a significant carve-out in our legal system, addressed in Sections 42 and likely reinforced by Section 45, concerning the protection of members of armed forces from arrest. These sections provide special protection for members of the armed forces, Army, Navy, Air Force, from arrest by ordinary civilian police officers, specifically when they're carrying out their official duties. The likely repetition in Section 45 just underscores how important this protection is considered. The core protection is essentially an immunity from arrest for actions taken during official duty. Section 42 states, "No member of the armed forces of the Union shall be arrested for anything done or purported to be done by him in the discharge of his official duties, except," and this is the crucial part with the explicit, "consent of the central government."
Consent from the central government, so local police can't just decide to arrest a soldier on duty.
Generally, no, not without that high-level consent. This is designed to recognize the unique command structure and operational requirements of the armed forces. It prevents situations where, say, soldiers involved in sensitive operations like counterinsurgency or border control could be arbitrarily arrested by local police for actions taken during that duty. It ensures they can perform their tasks without the constant fear of immediate civilian legal interference. The primary accountability for actions done in the discharge of official duties lies within the military justice system, unless the central government specifically permits civilian prosecution by giving that consent for arrest. The section also mentions that the central government can, by notification, lift this immunity for specific classes or categories of personnel or in specific areas if needed. And if there's ever a question about whether someone is armed forces personnel or if their action was official, a certificate from their commanding officer is considered conclusive evidence.
Okay, let's take an example. Imagine during an anti-terrorist operation, a soldier, let's call him Mr. S, fires his weapon and accidentally injures a civilian nearby. Local police arrive and want to arrest Mr. S for causing grievous hurt. Under Section 4201, since Mr. S was arguably acting in the discharge of his official duties during that operation, the police generally cannot arrest him without obtaining the consent of the central government first. This prevents immediate disruption of potentially ongoing military operations and maintains military discipline.
Precisely. The likely inclusion of Section 45, repeating or elaborating on this protection, really emphasizes how critical this safeguard is viewed. It highlights the unique status of military personnel and the necessity of such provisions for national security and the effective functioning of the armed forces. It reflects the principle that their accountability for actions taken in the line of duty is primarily handled through military law unless the central government specifically decides otherwise.
Understood. So we have immediate arrests without warrants for urgent situations, Section 35. Special rules for the military, Sections 42, 45. What about the standard, more common, judicially authorized way to get someone arrested, especially when there is time for due process or for less serious offenses?
That brings us squarely to Section 43, arrest by order of a magistrate. This section describes the warrant system, the cornerstone of judicially authorized arrest. This is the method used when a magistrate, after applying their judicial mind and reviewing the information presented to them, believes it's necessary for a person to be taken into custody. They then authorize this by issuing an arrest warrant. The process starts when a magistrate having jurisdiction over the case believes, based on a complaint or police report, that a person has committed an offense. They may then issue a warrant for his arrest. Notice the difference from Section 35. This involves prior judicial authorization. The magistrate acts as a check. The warrant itself has formal requirements. It must be in writing, signed by the presiding officer of the court, and bear the seal of the court. This ensures its authenticity. It's typically directed to one or more police officers, instructing them to make the arrest. However, it can also be directed to any other person if, say, a police officer isn't immediately available and there's urgency. The warrant must clearly specify the name of the person to be arrested, the offense they are accused of, and the direction to bring that person before the court. There's also flexibility. A magistrate can endorse a warrant as bailable. This allows the police executing the warrant to release the arrested person on bail themselves right after the arrest if certain conditions, like providing sureties, are met. This is common for less serious offenses.
Right. So this warrant system is the standard procedure for non-cognizable offenses, where police can't arrest without one, correct? And also maybe for cognizable offenses where the accused is known, but immediate police arrest isn't deemed necessary or feasible. Its main goal is getting the person to court.
Precisely. It's the primary method for initiating arrest in non-cognizable cases. It's also used frequently in cognizable cases when the identity of the accused is known, but perhaps they aren't immediately findable, or the police decide a warrant is the appropriate route rather than an immediate warrantless arrest. Its core purpose is indeed to compel the appearance of an accused person before a court for trial or inquiry. The judicial authorization involved provides that crucial check on the power to arrest, ensuring there are sufficient grounds presented before someone's liberty is curtailed by the state.
Let's illustrate. Imagine Mrs. Z files a private complaint directly with a judicial magistrate alleging defamation against Mr. Y. Defamation is typically a non-cognizable offense. The magistrate examines Mrs. Z's complaint, maybe hears her initial statement, and believes there are sufficient grounds to proceed. The JMFC then issues an arrest warrant for Mr. Y. A police officer, or another person authorized by the warrant, then finds Mr. Y, shows him the warrant, arrests him, and produces him before the JMFC as directed. It's the legal system saying, we've reviewed this and we authorize this arrest under judicial oversight. Okay, so magistrates issue warrants. But what about the higher courts themselves? Do they have a direct power of arrest, similar to the magistrates we discussed earlier under Section 41? Can a Sessions Court judge, for example, order an arrest directly from the bench?
Yes, they can. Section 44 deals with arrest by court. And court here explicitly includes not just magistrates' courts, but also higher courts like courts of session and even high courts. This power is quite similar to the magistrate's power under Section 41, but it's specifically attributed to a court as an institution. It's seen as essential for maintaining the dignity, authority, and proper functioning of judicial proceedings. Again, there seem to be two main scenarios outlined. First, similar to magistrates, if any offense is committed in the presence of any court, high court, sessions court, magistrates court, in such a case, such court may cause such person to be arrested and may thereupon commit the offender to custody. This power is vital for maintaining decorum and addressing immediate disruptions or criminal acts happening right there within the judicial precincts. It allows the presiding judge or magistrate to take swift action against someone committing a crime in their presence, protecting the sanctity of the court. The second scenario, under subsection 2, mirrors Section 41D for magistrates. It says, any court may at any time arrest or direct the arrest, in its presence, within the local limits of its jurisdiction, of any person for whose arrest it is competent at the time and in the circumstances to issue a warrant. Now, the source material intriguingly notes that Section 44.2 refers back to the provisions of subsection 1 of Section 35.
Back to Section 35. The grounds for police warrantless arrest. How does that connect?
It's a crucial link. It means if a court is dealing with a matter, maybe hearing a case, and it becomes apparent during those proceedings that a person who is present in the court has committed a cognizable offense or meets other grounds under Section 35.1, like being a proclaimed offender, the court can immediately order their arrest. They don't need to go through the formality of issuing a separate arrest warrant for someone who is already standing right there before them. It demonstrates the court's overarching authority to enforce the law directly when the situation arises during its own proceedings.
Let's take examples. Scenario 1. During a really heated argument in a Sessions Court trial, one witness suddenly physically assaults another witness. The Sessions judge can immediately order court staff or police present to arrest the assaulting witness right there in the courtroom and commit them to custody. That's immediate justice in action. Scenario 2, linking to Section 35. Mr. Q is present in a judicial magistrate's court, maybe just as a witness in a minor traffic case. During the proceedings, credible information comes to the magistrate's attention, perhaps from a lawyer or police officer present, that Mr. Q has just committed a theft, a cognizable offense under Section 35.1 right outside the courtroom minutes ago. Since the magistrate would normally be competent to issue a warrant for theft and Mr. Q is right there, they can immediately order Mr. Q's arrest under Section 44.2, invoking the grounds similar to Section 35.1, even though he was initially present for a different reason. It avoids unnecessary procedural delay.
Exactly. That connection to Section 35.1 is fascinating. It underscores that the court's power isn't just about maintaining internal order, but also about the effective and immediate administration of criminal justice for serious offenses that come to light during its own proceedings when the alleged perpetrator is present.
Okay, we've covered a lot about who can make an arrest and under what circumstances. But once someone is actually taken into custody, what are the mandatory steps to protect their well-being, their rights? What happens after the arrest itself? This seems to move us into the critical post-arrest phase.
It does, and the law lays out a series of crucial safeguards and procedures for this phase. Just before we dive into those specific safeguards, it's worth mentioning Section 46, Classes of Criminal Courts. We've been talking about magistrates and courts, and this section essentially reiterates the hierarchy laid out earlier in the BNSS, Section 6. It lists the classes. Courts of session at the top for serious cases, then judicial magistrates of the first class, judicial magistrates of the second class with lesser powers, and also executive magistrates. Its placement here within the Arrest of Persons chapter isn't just repetition. It serves as a constant reminder of the different authorities involved in the whole arrest ecosystem, issuing warrants, taking cognizance, ordering custody, overseeing procedures. It underscores that these powers are distributed across distinct judicial and executive tiers.
Got a quick map of the players. Now, let's talk about one of the most vital safeguards for anyone who finds themselves arrested, their physical well-being, right from the moment they are taken into custody.
Yes, this is incredibly important, and it's a mandatory procedure under Section 47. Examination of arrested person by medical practitioner. This isn't just about checking if someone needs first aid. The medical examination serves as a critical safeguard against custodial torture or brutality, and it can also be a crucial piece of evidence later on. Section 47 mandates this examination. Subsection 1 is key. It says the examination should happen immediately after the arrest is made. There's an urgency there. It also allows for examinations at reasonable intervals during his detention if the arrested person requests it. Who conducts it? It has to be a registered medical practitioner, preferably one employed in a hospital or dispensary run by the government or by a local authority. And crucially, if the arrested person is female, the examination must be made only by or under the supervision of a female registered medical practitioner. This ensures privacy and sensitivity.
What does the doctor actually record?
The medical practitioner must prepare a record of the examination. This record needs to detail any injuries or marks of violence found upon the person of the accused. And, importantly, it should also record the approximate time when such injuries or marks may have been inflicted. This timing can be vital evidence. And for transparency, a copy of this examination report shall be furnished to the arrested person or to their nominated person, like their lawyer. Subsection 2 adds that even if an initial exam wasn't done properly, or if a further examination is needed later for evidence, a magistrate can order one, especially relevant for arrests made without a warrant, linking back to that Section Con 5.1 category.
Okay, but why immediately after arrest? What's the real practical benefit of this mandatory medical report for you, the arrested person, and maybe even for the police?
The immediacy is key. This section acts as a powerful deterrent against police brutality or torture after the arrest. Any injuries inflicted after the arrest but before this mandatory medical examination would likely be documented by the doctor. This makes it much harder for police to later deny responsibility or claim the injuries were pre-existing. Conversely, it also protects police officers from false allegations of brutality if the arrested person already had injuries when they were apprehended. The report establishes a baseline physical condition at the time of arrest. Beyond preventing abuse, the report can sometimes provide crucial forensic evidence related to the offense itself. And furnishing a copy promotes transparency and allows the arrested person or their lawyer to challenge any discrepancies or omissions later. It creates that documented paper trail for the physical condition of the person, literally.
So let's revisit Mr. V, arrested on suspicion of robbery. He later claims that police assaulted him during or right after the arrest. Section 47(1) mandates that the police take Mr. V immediately after the arrest to a government hospital or registered practitioner. The doctor examines him, notes any abrasions, bruises, other injuries, and estimates when they might have occurred. A copy of that report, given to Mr. V or his lawyer, becomes absolutely crucial evidence if he alleges custodial violence. Right. So Section 47 covers physical well-being through medical checks. But what about the broader spectrum of rights? If you're arrested, what are all your entitlements, beyond just the medical exam and knowing why you're being held? Is there a single place listing them?
Yes, the BNSS aims to consolidate this. Section 48 is titled Rights of Arrested Person. While many individual rights are scattered across this chapter, like the right to know grounds, Section 36, or right to a lawyer during interrogation, Section 38, Section 48 seems intended to serve as that crucial consolidation. Think of it as a comprehensive Bill of Rights outlining the key entitlements of an arrested person. It's meant to be your legal playbook if you find yourself in that tough spot. This section would likely bring together the various rights recognized under the Constitution, Articles 20, 21, 22, and detailed in other BNSS sections, so it would probably include the right to know the grounds of arrest, as in S36, the right to inform a friend or relative, S36 again, the right to consult a legal practitioner of choice, especially during interrogation, S38, the right to be produced before a magistrate without unnecessary delay within 24 hours, which we'll detail in S428, the right to a medical examination, S47, the fundamental right against self-incrimination, essentially, the right to remain silent, the right to be released on bail if the offense is bailable, and the implicit right to protection from torture or ill treatment flowing from the constitutional right to life and dignity.
Okay, but why consolidate all these rights into one section if some are already detailed elsewhere? What's the real benefit, especially for you, the listener, in having them all listed together in Section 48?
The power of consolidation here is significant. It makes these rights more accessible and visible. It empowers arrested individuals and their legal representatives to clearly understand and demand these rights as a package. It provides a single, clear legal basis for holding police and other authorities accountable if any of these rights are violated. It fundamentally underpins the principle of fairness during those critical initial stages of criminal justice, acknowledging the inherent vulnerability of a person in custody. Having Section 48 means it's a clear, accessible statement of entitlements that can be immediately invoked. If Mr. B is arrested and officers just start questioning him without informing him of anything, he or his lawyer, once contacted, can immediately point to Section 48 and demand his rights of arrested person be respected, grounds of arrest, call to family, access to lawyer before interrogation proceeds. The police are legally bound to uphold these.
Makes sense. Now, part of respecting an arrested person's rights and dignity must also involve how they are physically handled while in custody. Can police just use any level of force or restraint they feel like? Handcuffs for everyone.
Absolutely not. Section 49 specifically addresses this. No unnecessary restraint of arrested person. This section is fundamentally about respect and dignity, even for someone under arrest. It explicitly prohibits the use of unnecessary restraint or force. The core principle stated is, no person arrested shall be subjected to more restraint than is necessary to prevent his escape. That preventing escape is the sole justification legally allowed for imposing restraint. This safeguards the dignity and physical integrity of the arrested person. It acts as a crucial check against things like excessive force during handling, arbitrary handcuffing when there's no flight risk, or other forms of physical restraint that are not genuinely required just to prevent escape. It mandates proportionality.
So let's consider Mr. C, an elderly, perhaps infirm man with no history of violence, arrested for a minor bailable offense and brought calmly to the police station. If the police officers immediately handcuff him tightly to a bench inside the station, would that violate Section 49?
It very likely could. Unless Mr. C was actively trying to escape or showing clear signs of violence or posing a threat, such restraint might easily be deemed more restraint than is necessary to prevent his escape, and therefore potentially unlawful under Section 49. The level of restraint should always be proportionate to the actual risk posed by the individual and the circumstances. It should be limited to what is reasonably required to keep them securely in custody, not used as a form of punishment, intimidation, or humiliation. And this emphasis on proportionality and restraint is vital. Why? Because even a person under arrest retains their fundamental human dignity. Section 49 prevents undue humiliation and acts as another powerful check against potential abuse of power. It ensures that physical discomfort is minimized to the bare essential required for security.
Okay. Beyond physical restraint, when someone is arrested, they often have personal belongings on, wallet, phone, keys, maybe other items. What can the police do with those? Can they search you? And are there special considerations, maybe again for women?
Yes, the police absolutely have the power to search an arrested person. But, like everything else we've discussed, there's a clear procedure outlined, and yes, a very important specific safeguard for female arrestees. This is covered in Section 50. Power to search arrested persons. This power applies in various situations where a lawful arrest has been made. Under a warrant that doesn't provide for bail, under a bailable warrant where the person can't furnish bail, or whenever a person is arrested without a warrant by police or handed over after a citizen's arrest, who conducts the search. The officer making the arrest, or if the arrest was made by a private person, the police officer to whom the arrested person is handed over, what can they seize? The officer may search such person and is empowered to place in safe custody all articles other than necessary wearing apparel found upon him. So this allows for the seizure of pretty much everything found on the person except their essential clothing, unless, of course, the clothes themselves are evidence. Maybe they're bloodstained or torn during a crime.
What about documenting what's taken?
Absolutely crucial. The officer shall cause to be prepared a list of all articles seized and shall supply a copy thereof to the arrested person or to a relative or agent of such person. This ensures transparency and provides a record. The section also specifically directs that any offensive weapons which may be found on the arrested person shall be seized. That's a clear priority for safety. And then comes the crucial proviso regarding female searches. Provided that when it is necessary to cause a female to be searched, the search shall be made by another female with strict regard to decency.
Okay, let's walk through that. Mr. D is arrested for a serious offense, brought to the station. The arresting officer searches him. They find a small knife in his pocket, a wallet with cash and ID cards. The knife, an offensive weapon, and the wallet's contents, other articles, are seized and placed in safe custody. The officer must prepare a list of all articles seized, e.g., one knife, one wallet containing euro of cash, one ID card of Mr. D, and give a copy of this list to Mr. D, or maybe his lawyer if present. Mr. D's shirt and pants are not seized unless they are potential evidence themselves. Now, if Mrs. E is arrested, any search of her person must be conducted by a female police officer, or perhaps another designated female staff member, and it must be done with strict regard to decency, for instance, likely in a private room, avoiding unnecessary exposure or physical contact. That seems like a fundamental protection.
It is fundamental. That proviso for female searches is incredibly important. While the whole section is vital for both security, seizing weapons, protecting officers, and evidence collection, finding stolen goods, etc., that requirement for a list of seized articles and providing a copy is key to preventing later allegations of theft by police or planting of evidence. But the proviso for female searches is a clear statutory recognition of the need to protect the privacy, dignity, and bodily integrity of female arrestees. It aims to minimize discomfort and the potential for abuse during a search procedure. It ensures dignity is maintained even in that situation.
Right. Now, building on that last point about seizing weapons from the arrested person, does that power extend beyond just the individual being arrested? What if others are present at the scene who might also be armed?
Yes, the law anticipates that possibility. Section 51 deals with the power to seize offensive weapons, but with an extended scope. This section appears to expand the power to seize offensive weapons beyond just the person being arrested, potentially including any other person present during a specific type of arrest. It seems primarily focused on ensuring the safety of officers during the apprehension process. The context here seems specific. It applies when any person is arrested by a police officer under a warrant. In that scenario, the power to seize applies not just to offensive weapons found on him, the person named in the warrant, but also potentially to weapons found on any other person in his presence. The police officer executing the warrant may seize such weapons directly from that other person, too.
Let's illustrate that. Imagine police officers arrive at Mr. F's house, armed with an arrest warrant specifically for Mr. F. They enter the house to make the arrest. Mr. F brother, let's call Mr. G, is also present, maybe standing near Mr. F. The police notice a pistol tucked into Mr. G's waistband. Now, even though the arrest warrant is only for Mr. F and Mr. G is not currently being arrested, the police officer who is there executing a warrant of arrest for Mr. F sees offensive weapons, the pistol, found on any other person in his presence, Mr. G. Under Section 51, that police officer is legally empowered to immediately seize the pistol from Mr. GY to ensure the safety of the entire operation. It's about immediately neutralizing potential threats from anyone nearby who might endanger the officers or facilitate Mr. S' escape.
Exactly. This section serves as a critical safety measure for police officers. Arrest situations can be unpredictable and dangerous. Section 51 allows them to immediately address potential threats not just from the person they are arresting, but also from associates, accomplices, or just other individuals present at the scene who might be armed and could pose a danger. It provides the legal basis for seizing weapons from individuals who aren't the direct target of the arrest warrant, helping to create a safer environment for law enforcement to carry out their duty.
Okay, so items have been seized from the arrested person, Section 50, maybe weapons secured from others present too, Section 51. What happens to all those seized articles? Do they just sit in an evidence locker forever? And what if the suspect, instead of just having items on them, tries to evade arrest by physically taking refuge inside a building? What powers do the police have then to get them out?
Those are crucial next steps in the process, dealing with the aftermath of seizure and the challenges of apprehension. Let's first address what happens to the seized items. Section 52 deals with the disposal of articles seized from arrested persons. This isn't just about storage, it's about proper accounting, handling, and eventual disposition, all crucial for accountability and maintaining the integrity of evidence. The key requirement here is mandatory reporting. It states that whenever any article is seized under Section 50 from the arrested person, a report detailing the seizure shall be made to the magistrate having jurisdiction over the case. This reporting ensures judicial oversight. It prevents items from simply disappearing and provides a mechanism for the court to give directions on how the seized property should be handled, stored, or eventually returned or disposed of. It helps prevent misappropriation or tampering with potential evidence. There's a practical exception mentioned for perishable goods. If the articles seized are of a perishable nature, the report of seizure goes to the officer in charge of the nearest police station immediately after the seizure.
Why the local station chief for perishable stuff?
Practicality. This allows for immediate action like photographing the item, sending it for urgent forensic analysis if needed, like suspected poisoned food, or even disposing of it if it's rapidly deteriorating without having to wait for a formal order from a magistrate, which might take time and result in the evidence being lost. If you connect this to the bigger picture, Section 52 is an important link in establishing and maintaining the chain of custody for seized evidence. That unbroken chain, showing who handled the evidence and when, is absolutely crucial for its admissibility and credibility when the case eventually goes to court.
Okay, that makes sense. So if Mr. P is arrested, and during the search, under S50, police seize his mobile phone, his wallet, and a small packet of suspicious powder. The officer prepares the list, as per S50, and then must immediately make a report of this seizure to the magistrate, who has jurisdiction over the alleged offense. The items are then held in safe custody, as directed by the magistrate. But if instead of powder they seize a perishable food item suspected to contain poison, the seizure would be immediately reported to the officer in charge, SHO, of the nearest police station. The SHO would then ensure it may be photographed and sent for immediate forensic analysis to prevent its spoiling. It's about maintaining evidence integrity, preventing things from being lost or just disappearing. Right? That covers items seized from a person. But what about the situation where the person themselves is trying to evade arrest by hiding? Maybe they run into their house or someone else's house or an office building. Can the police just break down the door? That sounds like a pretty significant intrusion on property rights and privacy.
It is a significant intrusion, and therefore the law grants this power, but with very specific rules and safeguards. Section 53 covers the search of place entered by persons sought to be arrested. It gives police officers the crucial power to pursue suspects into premises, but under strict conditions. The grounds are clear. If a person acting under a warrant of arrest, or any police officer who has the authority to arrest, even without a warrant, like under Section 35, has reason to believe that the person they are trying to arrest has entered into or is within any particular place, a house, an office, any building. What happens first? Subsection 1 says the person residing in or who is in charge of that place shall, on demand by the officer, allow him free ingress thereto and afford all reasonable facilities for a search therein. So there's a legal obligation on the occupant to cooperate and let the police in to search for the wanted person.
But what if they refuse? Or just don't answer the door?
That's where subsection 2 comes in. If peaceful entry cannot be obtained, then it is lawful for the officer executing the warrant or having authority to arrest to enter such place and search therein. And crucially, to achieve this entry, the officer is empowered to break open any outer or inner door or window of any house or place if needed to get in. This power applies whether the place belongs to the person being sought or someone else entirely. They can also remove any other obstruction. Subsection 3 even allows officers to break out if they lawfully entered to make an arrest but are then somehow detained inside. They can break open a door or window to liberate themselves or anyone else lawfully assisting them. Now here comes a really crucial proviso, similar to the search safeguard but regarding entry into dwellings. Provided that if any such place is an apartment in the actual occupancy of a female, not being the person to be arrested, who, according to custom, does not appear in public.
Oh, the Parnashan woman consideration.
Exactly. For such a female occupant, such person or police officer shall, before entering such apartment, give notice to such female that she is at liberty to withdraw and shall afford her every reasonable facility for withdrawing. Only after giving this notice and opportunity to withdraw, may they then break open the apartment and enter it if necessary for the arrest.
This proviso seems incredibly important culturally and legally. Let's walk through the scenarios again. Scenario 1. Police have an arrest warrant for Mr. X. They track him to a specific house and have reason to believe he's inside. They knock, identify themselves, and demand entry to arrest Mr. X. The person in charge of the house must legally allow them free ingress. Scenario 2. If the occupant refuses to open the door, shouts, "Go away," or if maybe no one answers but police are reasonably sure Mr. X is inside, the police officer can now, under Section 532, break open any outer door, kick it down if necessary to enter and search for Mr. X. This applies even if the house belongs to Mr. X's cousin, not Mr. X himself. Scenario 3, the proviso. Now, if that same house is in the actual occupancy of Mrs. Y, a female who by custom observes Purdah and doesn't appear in public, and she is not the person police are there to arrest, and Mr. X is believed to be hiding inside her apartment within the house. Before breaking down Mrs. Y's door, the police must give notice to Mrs. Y that she is at liberty to withdraw. They have to give her a reasonable chance to leave that specific area. Only after doing that can they proceed with forcible entry into her apartment if needed to find Mr. X. That's a powerful balancing act, apprehending suspects versus respecting deeply held customs and female privacy.
It absolutely is. Section 53 provides the necessary legal teeth for police to pursue and apprehend suspects who try to evade arrest by taking refuge. It prevents suspects from simply barricading themselves and thwarting justice. But that proviso for female occupants is a vital safeguard. It reflects a deep-seated principle within our legal framework of respecting privacy and dignity, particularly for women observing certain customs, ensuring that this fundamental right is balanced against the legitimate needs of law enforcement.
Okay, so police can enter a place to find a person they need to arrest. But what if the police need to search a place perhaps urgently, not for a person, but to find evidence? Maybe specific documents, a weapon used in a crime, stolen goods, a laptop. And they believe waiting for a formal search warrant from a court might lead to that evidence being destroyed or moved. Can they search a place without a warrant just for things?
Yes, there is a provision for that, but again, it's under very specific regent conditions and comes with strict safeguards. This is covered by Section 54. Search of place by police for documents or things. Note the difference. Section 53 was about finding a person to arrest. Section 54 is about finding evidence, specific documents, or things relevant to an ongoing investigation. This section grants police the power to search a place without a search warrant obtained from a court, but only when certain criteria are met. Who can conduct such a search? An officer in charge of a police station, SHO, or a police officer who is actually making an investigation into an offense, investigating officer or IO. What grounds do they need? They must have reasonable grounds for believing that any document or thing necessary for the purpose of any investigation into any offense might be found within a place located within the limits of the police station they are attached to. Now, here is the crucial urgency clause that justifies bypassing the warrant requirement. The officer must be of the opinion that the document or thing cannot be otherwise obtained without undue delay. Waiting for a warrant would likely mean the evidence is lost.
So urgency is key. What safeguards are there if they bypass the court?
Very important safeguards. First, such an officer must, before conducting the search, record in writing the grounds of his belief and specify in such writing, so far as possible, the thing for which the search is to be made. This written record, made before the search, is a vital check against arbitrary action. Second, the officer should, if it's practicable, conduct the search in person. If they have to delegate it to a subordinate officer, they must issue a written order specifying the place to be searched and the specific things to look for. The subordinate cannot go beyond that written mandate. Third, and this is critical, the section explicitly states, the provisions of this Sanhita as to search warrants and the general provisions of this Sanhita relating to searches shall, so far as may be, apply to a search made under this section.
What does that mean in practice?
It means that even though this is a warrantless search based on urgency, all the other general procedural safeguards that normally apply to searches with a warrant must still be followed as much as possible. This typically includes things like the requirement to have 2 independent, respectable inhabitants of the locality present as witnesses during the search, usually under Section 100 of the BNSS, preparing a list, a panchnama or seizure memo, of anything seized during the search in the presence of those witnesses, and giving a copy of that list to the owner or occupant of the place searched. Fourth, another check. Copies of any record made, the grounds for belief, or any written order issued for the search shall forthwith be sent to the nearest magistrate who is empowered to take cognizance of the offense. This ensures prompt post facto judicial awareness of the warrantless search. And finally, the police officer conducting the search shall seize any articles found which they believe are necessary for the investigation, and shall forthwith bring them before the magistrate, unless they are authorized to keep them in custody pending the magistrate's orders.
Okay, let's use an example again. Police are investigating a major fraud case. They receive an urgent, credible tip that the main suspect's laptop, believed to contain critical, incriminating financial records, is currently at a specific office address within their police station limits and is about to be remotely wiped clean or physically destroyed within the next hour. Clearly, there's no time to apply for and obtain a search warrant from a magistrate. Under Section 54, the investigating officer, having reasonable grounds for believing the laptop is necessary for the purpose of investigation and cannot be otherwise obtained without undue delay, can take action. First, the IO must quickly record in writing the grounds of his belief, the urgent tip, risk of destruction, and specify the thing for which the search is to be made, the specific laptop. Then the IO proceeds to the office, conducts the search, ensuring they follow general search provisions like maybe getting 2 employees from a neighboring office to act as independent witnesses. They find and seize the laptop. Immediately after, the IO forthwith sends a copy of the recorded grounds for the search to the jurisdictional magistrate, and then produces the seized laptop before the magistrate for further orders, like sending it for forensic analysis. It sounds like a power born out of necessity, but one that's heavily layered with checks and balances to prevent misuse.
Precisely. And you asked earlier, why are the recording and writing beforehand and reporting to a magistrate immediately after so crucial? This power under Section 54 is absolutely critical for those situations where the delay in obtaining a formal search warrant would genuinely risk the destruction or concealment of crucial evidence. Think time-sensitive cases, digital evidence, etc. However, the mandatory recording of reasons before the search acts as an internal discipline and creates a contemporaneous record justifying the agency. The insistence on adhering to general search safeguards, like witnesses, provides transparency during the search itself. And the immediate report to a magistrate provides that vital post facto judicial oversight and accountability. It ensures that even when urgency demands bypassing prior judicial authorization, the process remains legally sound and reviewable after the fact.
Okay, so we've covered finding a person hiding off O3 and finding urgent evidence, OS54. But what happens if the person has already been arrested and is in lawful custody but then manages to escape? Or maybe they are rescued by accomplices. Does the law just throw its hands up then?
Absolutely not. The law is very clear on this. Section 55 addresses the arrest and retaking of persons who have escaped. It provides a sweeping, almost universal power to pursue and bring back anyone who escapes from lawful custody, regardless of where they might run. The conditions are simple. If a person in lawful custody escapes or is rescued, this covers both the person actively breaking free and situations where others help them escape. Who has the power to pursue and rearrest? The authority is granted very broadly to the person from whose custody they escaped or were rescued, e.g. the police officer, the jail guard. Any police officer, whether involved initially or not, or even any other person, which implies a private citizen, could also act to rearrest an escapee. Importantly, there are virtually no jurisdictional limits for this pursuit. The pursuit and rearrest can happen in any place in India, transcending the usual state or district boundaries that might limit other police actions.
Anywhere in India. That's broad.
It is. And Section 552 makes another crucial link. The provisions of Section 53 shall, so far as may be, apply to arrests under subsection 1 of Section 55. This means that the power to search premises for a person who is sought to be arrested, which we just discussed under Section 53, including the power of forced entry if necessary, also applies when police or others are trying to rearrest someone who has escaped from lawful custody.
Let's illustrate. Imagine Mr. H, who was lawfully arrested by the Delhi police for a serious crime, is being transported by train to appear in court. When the train makes a brief stop in a rural area of Uttar Pradesh, Mr. H somehow manages to overpower his escorts and escape from police custody. Under Section 55(1), the Delhi police officers from whom he escaped can immediately pursue and arrest him, even though they are now in Uttar Pradesh, in any place in India. Additionally, any local UP police officer who learns of the escape, or even a private citizen in that village who witnesses the escape, or perhaps recognizes Mr. H as an escaped prisoner, can also legally arrest him. Now, if Mr. H then runs and takes refuge inside a house in that UP village, the pursuing police officer, whether from Delhi or local UP police, can, under Section 55(2), read, together with Section 53, exercise the powers to demand entry, search that premises, and even forcibly enter if denied access, in order to reapprehend Mr. H. It really underscores the idea of maintaining the integrity of the justice system you can try to run, but the law gives broad powers to ensure you can't truly hide from lawful custody indefinitely.
Exactly. Section 55 is vital for that very reason, maintaining the integrity of the criminal justice system. It ensures that individuals cannot simply evade justice by escaping custody. It grants that universal power of rearrest, recognizing that an escaped individual inherently poses a potential threat or risk, and their apprehension is paramount. It overrides normal jurisdictional limits specifically for this act of recapture. It serves as a strong deterrent against attempting escape and ensures efficiency in reapprehension without needing fresh warrants or complex interstate jurisdictional clearances.
Okay. We seem to be covering all the key powers and procedures now. We've walked through who can arrest, when, how, the rights involved, dealing with searches, and even handling escapes. But what about the absolute, non-negotiable safeguards that protect an arrested person from simply languishing in detention arbitrarily? And what ensures humane treatment throughout? What are the ultimate principles governing all these arrests?
We're moving into the core safeguards against arbitrary detention and the overarching principles that tie this whole chapter together. Let's start with a fundamental human right, one that flows directly from the constitutional right to life and personal liberty. Article 21. Section 56 deals with the health and safety of arrested person. Once someone is taken into state custody, this section places a positive, non-negotiable legal duty on the authorities holding them to prioritize and ensure their health and safety. The duty falls on the person having custody of accused. This refers broadly to anyone legally responsible for holding an arrested person, the arresting police officer, the officer in charge of the police station lockup, jail authorities if remanded, or any other officials temporarily entrusted with custody. They have a duty to take reasonable care. Notice the word reasonable. It implies measures proportionate to the circumstances, the known health conditions of the arrested person, and the facilities available. But duty imposes an active obligation, not just a passive one of avoiding harm. What does reasonable care cover? It explicitly includes ensuring the health and safety of the accused. This encompasses both physical and mental well-being. It implies providing adequate food, water, sanitation, necessary medical attention, and protection from harm, whether from illness, injury, psychological distress, harm inflicted by other inmates or even personnel, or self-inflicted harm.
Okay, let's make that practical. Mr. A is arrested for a crime. The police know, or he tells them, that he is a diabetic and needs regular insulin shots. While he's being held in the police lockup overnight pending production before a magistrate, he starts feeling unwell and requests his medication. Under Section 56, the officer in charge of the lockup, the person having custody, has that duty to take reasonable care for Mr. A's health and safety. What does that mean here? It must entail promptly providing his medication if available, or ensuring he receives immediate medical attention from a doctor. Failure to do so, if it leads to Mr. A's health deteriorating significantly, would be a direct violation of this duty. Similarly, if an arrested person shows clear signs of severe depression or suicidal thoughts, the authorities would have a duty under this section to take reasonable measures to prevent self-harm. perhaps including closer observation and consultation with mental health professionals. It's about proactively preventing custodial tragedies and ensuring humane treatment.
Precisely. If we connect this to the bigger picture, Section 56 serves as a direct legal deterrent against custodial deaths, torture, and ill treatment that might arise from negligence or deliberate denial of care. By placing this positive duty squarely on the custodian, it makes them legally accountable for the well-being of the person in their charge. Failure to adhere to the standard of reasonable care can lead to serious consequences for the officials involved: disciplinary action, criminal charges like causing death by negligence, and civil suits for damages. It's a vital human rights provision ensuring that basic dignity and care are maintained even during detention.
Ensuring health and safety is critical. But we touched on this earlier. How long can someone actually be held by the police after arrest, but before their arrest is formally reviewed by a magistrate? What is the absolute time limit on that initial police detention, especially for those arrested without a warrant?
This brings us to another fundamental safeguard against arbitrary and potentially prolonged police detention. Section 57 is titled, "Person arrested to be taken before magistrate or officer in charge of police station." This mandates that a person arrested without a warrant cannot just disappear into police custody indefinitely. They must be brought before a judicial authority or, at the very least, a senior police officer without unnecessary delay. This section applies specifically to a police officer making an arrest without warrant. The key word is urgency. Shall, without unnecessary delay. This emphasizes that any delay that isn't genuinely required for the immediate necessities of the arrest or investigation, and importantly excluding travel time as we'll see in S558, is unacceptable. There's also a caveat, subject to the provisions of this Sanhita as to bail. This indicates that if the offense is bailable and the person can meet the conditions, like providing sureties, they might be released on police bail directly from the station itself, as per the procedures likely detailed around Section 36 or bail-specific sections. But if they aren't released on bail, the arrested person must be taken or sent before a magistrate having jurisdiction in the case, or before the officer in charge of a police station.
Why those two options? Magistrate or the SHO?
This seems to offer two immediate avenues for review and record keeping. Production before a magistrate allows for independent judicial scrutiny of the arrest's legality and the need for further detention. Production before the officer in charge of the police station, the SHO, ensures that the arrest is formally recorded in station diaries, the SHO is made aware, and it offers that crucial early opportunity for considering police bail if the offense is bailable. This provides a significant practical benefit for the arrested person in bailable cases. Section 57 acts as the first mandatory checkpoint against any unrecorded or potentially unlawful detentions immediately following a warrantless arrest.
Okay, so Section 57 requires production without unnecessary delay. And that leads us directly, as you mentioned, to the absolute non-negotiable time limit on detention without specific judicial sanction.
Yes.
That's the famous 24-hour rule, right?
Exactly. This is where it gets really critical, and it's one of the most fundamental constitutional protections reflected in the BNSS. Section 58 lays down, person arrested not to be detained more than 24 hours. This section mandates that no arrested person can be held in police custody for more than 24 hours without being produced before a magistrate. This is a cornerstone safeguard against arbitrary and prolonged detention by the executive, the police. The section starts with a general principle. No police officer shall detain in custody a person arrested without warrant for a longer period than under all the circumstances of the case is reasonable. But then it lays down the absolute maximum time limit. That period shall not, in the absence of a special order of a magistrate under Section 187, exceed 24 hours exclusive of the time necessary for the journey from the place of arrest to the magistrate's court.
Okay, let's be clear on that, exclusive of the time necessary for the journey.
Yes, this is a crucial practical clarification. If someone is arrested in a very remote area, and it takes, say, 10 hours just to travel to the nearest magistrate, that 10-hour travel time does not count towards the 24-hour limit for detention in police custody before production. The clock for the 24 hours essentially pauses during that necessary transit time. The only way detention by the police beyond this 24-hour period plus travel time is legally permissible is in the absence of a special order of a magistrate under Section 187. Section 187 of the BNSS, which is analogous to Section 167 of the old CrPC, deals with the procedure when investigation cannot be completed within 24 hours. It allows a magistrate, upon production of the accused, to authorize further detention either in police custody, remand, for a limited period if investigation requires it, or more commonly in judicial custody, jail, if satisfied that grounds exist.
So let's rerun my earlier example. Arrested in a remote village at 10 a.m. on Monday. Nearest magistrate is a 3-hour journey away. The police cannot hold the person in their custody at the station or anywhere else beyond 10 a.m. on Tuesday. That's 24 hours. They must produce the person before the magistrate by effectively 1 p.m. on Tuesday, 10 a.m. Tuesday, plus 3 hours travel. Is that right?
That's the correct understanding. The 24 hours is for the detention itself. The necessary travel time is added on top. This Section 58 is the statutory embodiment of the fundamental right guaranteed under Article 22 of the Constitution of India. This 24-hour rule is an incredibly powerful safeguard against illegal confinement by the police. It ensures that the legality of the arrest itself and the grounds for any continued detention are scrutinized by an independent judicial authority promptly. Any detention by police beyond this period, plus travel time, without a magistrate's specific authorization under Section 187 is illegal detention. It can lead to immediate release through a habeas corpus petition and potentially other serious legal consequences for the officers involved. It highlights the absolutely critical role of judicial remand in legalizing any detention beyond this initial 24-hour window.
Okay, so every arrest without warrant has this strict 24-hour clock for production before a magistrate. How does the broader system keep track of all these arrests happening across different police stations? Who gets notified administratively about all these apprehensions?
There's an administrative reporting requirement for that. Section 59 deals with police to report apprehensions. This section establishes a crucial administrative check and balance. It requires police officers, specifically officers in charge of police stations, SHOs, to maintain records and report details of arrests they've made to their superiors, and importantly, to specific executive judicial authorities. Who reports? The SHOs. To whom do they report? They shall report to the district magistrate, DM. Or if the DM directs, they can report to the subdivisional magistrate, SDM, for their respective area. What information needs to be recorded? The section specifies reporting the cases of all persons arrested without warrant within the limits of their respective stations, whether such persons have been admitted to bail or otherwise.
So it's a comprehensive report covering everyone arrested without a warrant, regardless of whether they got bail from the station or were sent to the magistrate.
Exactly. It ensures that the executive side of the magistracy is kept informed.
But why report these arrests to the DM or SDM, the executive magistrates? What's their role here? Aren't arrests mainly dealt with by judicial magistrates?
That's a great question. This reporting mechanism under Section 59 is vital for executive oversight and, again, for preventing unreported or off-the-books arrests. Remember, the district magistrate, DM, and subdivisional magistrate, SDM, are executive magistrates who have overall responsibility for the administration and maintenance of law and order within their district or subdivision. This reporting allows them to monitor the arrest activities of the police force operating within their jurisdiction. It ensures that a formal administrative record of all warrantless arrests is maintained and reported upwards to a higher executive authority. This significantly reduces the chances of unrecorded or potentially illegal detention slipping through the cracks. This data is also essential for compiling crime statistics, understanding policing patterns, and informing policy decisions related to law and order. It acts as a crucial administrative check on police discretion and can help identify any potential patterns of misuse of arrest powers within a particular area.
Right. So let's say over a week, the officer in charge of police station X makes 10 arrests without warrant. Some of those individuals were released on police bail from the station itself for bailable offenses. Others were forwarded to the judicial magistrate and may be remanded to judicial custody. Under Section 59, the SHO of Station X must periodically, maybe daily or weekly, depending on local rules, submit a report detailing all 10 of these arrests, who was arrested, for what offense, and whether bail was granted or not to the district magistrate or the relevant SDM. It functions like a transparent administrative ledger for police actions, ensuring accountability at a higher administrative level, complementing the judicial oversight from the magistrates. Okay, so we have detailed rules for making arrests, for detention periods, for reporting arrests. What about the other side of the coin? How and when can a person who has been lawfully arrested be lawfully released from custody? Are there specific rules for discharge, too?
Absolutely. Just as there are strict rules for making an arrest and detaining someone, there are equally strict rules governing their release from custody. Section 60 covers the discharge of person apprehended. This section essentially ensures that once a lawful arrest has been made, any subsequent release from that custody is also authorized by law. It prevents arbitrary or unauthorized discharges by police or other authorities. The section lays out the only permissible ways an arrested person can be discharged. No person who has been arrested by a police officer shall be discharged except, and then it lists the legal grounds, on his own bond or on bail or under the special order of a magistrate. Let's break those down. On his own bond. This usually applies to bailable offenses where the accused executes a personal recognizance bond, simply promising in writing to appear in court when required without needing sureties. On bail, this covers situations where bail conditions, like providing sureties or depositing a sum, are met for bailable offenses, or importantly, when a court, magistrate or higher, grants bail for a non-bailable offense after considering the case, under the special order of a magistrate. This is a catch-all for various scenarios where a magistrate or court directs release. This could be because the complaint is dismissed, the accused is acquitted after trial, the sentence served is completed, or maybe the charges are dropped during the investigation phase and the magistrate orders release.
Okay, but why is it so crucial that every release is formally authorized by law in one of these ways? Why can't the police, for instance, just decide to let someone go if they quickly realize they arrested the wrong person, or if the complainant withdraws the case informally?
Accountability and the rule of law. Section 60 ensures complete accountability for every single person taken into custody. Once someone is lawfully arrested, their liberty is curtailed under legal authority. Their release must also happen under legal authority. It prevents the possibility of arbitrary releases or potentially corrupt, unauthorized discharges by police or other officials. It reinforces the fundamental principle that both custody and release are matters strictly governed by legal process, not by individual discretion outside the law. Every person arrested must either remain in legally sanctioned custody, be released on legally defined terms, bond or bail, or be released specifically by a court order. This maintains the integrity and transparency of the entire criminal justice process from start to finish.
So, using our examples again, Mr. E is arrested for a bailable offense. He manages to arrange sureties and furnishes the required bail bond at the police station. Under Section 60, the SHO will discharge Mr. D on bail, as this is a legally permissible mode of release. Scenario 2. Mr. E is arrested and produced before a magistrate. After hearing initial arguments, the magistrate finds there are no sufficient grounds to proceed with the case and orders Mr. E's immediate release. Under Section 60, the police or jail authorities, if he was already remanded, will discharge Mr. E based on that special order of a magistrate. Unquote. Every step from arrest right through to potential release is governed strictly by the provisions of the law.
Got it. Now, we talked about the power to pursue and rearrest someone who has escaped custody earlier under Section 55. Then Section 61 seemed to reiterate that. Why the repetition?
That's a fair observation. Section 61, titled Power on Escape to Pursue and Retake, does sound very similar to Section 55. Given that Section 55 already detailed the broad power to pursue and rearrest and escape anywhere in India and linked it to the entry search powers of Section 53, Section 61 likely serves primarily as a reinforcement of that critical power. Sometimes legal codes repeat or reemphasize key principles. It underscores the immediate, broad, and geographically unlimited authority granted to police and even private persons to pursue and rearrest an individual who has escaped from lawful custody. It serves to emphasize the criminal justice system's unwavering commitment to preventing individuals from evading the legal process through escape and highlights the paramount importance of bringing them back into lawful custody swiftly. It's the legal system essentially saying, again, escape is not an option we tolerate.
Makes sense. A strong reiteration. Okay, we've covered the powers, the procedures, the rights, the safeguards, handling evidence, searches, escapes, releases. Now, to wrap up our deep dive into this arrest of persons chapter, is there one ultimate overarching principle that governs every single aspect of arrest we've discussed? Something that forms the absolute bedrock of legality?
Yes, there is. The final section in this chapter, Section 62, lays down exactly that. It's titled, Arrest to be Made Strictly According to Sanhita. This section serves as the overarching mandatory principle for the entire process of arrest. It imposes a strict legal obligation that all arrests must be conducted precisely according to the procedures and powers laid down in this code, the Bharatiya Nagrik Suraksha Sanhita 2023, or, importantly, under any other specific law that also provides for arrest. This is the ultimate guarantee against arbitrary arrests and the foundation for protecting fundamental rights in this context. Let's look at the wording. Arrest shall be made strictly according to the provisions of this Sanhita. This makes the BNSS the primary authoritative guide for how arrests must be conducted by police, magistrates, courts, and even private persons. Any significant deviation from its prescribed procedures, whether regarding the grounds for arrest, the manner of arrest, informing the person of their rights, the medical examination, the 24-hour production rule, the search procedures, or any other specific detail we've discussed potentially renders the arrest unlawful, it also adds, or any other law for the time being in force providing for arrest. This is crucial because it acknowledges that other specific statutes, like, say, the Customs Act, the NDPS Act for drug offenses, the PMLA for money laundering, might have their own special provisions regarding arrest powers and procedures for offenses under those specific laws. If an arrest is made under such a special law, it must strictly conform to that law's specific provisions. If the special law is silent on a particular aspect of arrest procedure, then the general provisions of the BNSS would likely fill the gap. But where the special law provides a specific directive, for example, maybe different reporting requirements, that special law's directive would typically prevail for arrests under that act. This reflects the legal principle of lex specialis derogat legi generali. A specific law overrides a general one on the same subject.
So Section 62 essentially says, follow this rulebook, the BNSS, or the specific rulebook for certain special offenses, but you must follow a rulebook strictly. What does this absolute requirement for strict adherence mean in practical terms for you, the listener? Why is that phrase, strictly according to Sanhita, such a powerful, binding command?
It's powerful because it firmly establishes that the act of arrest, which is a profound interference with a person's fundamental right to liberty, is governed entirely by the rule of law, not by the arbitrary whim or discretion of the arresting authority. An arrest that is not made strictly according to the law is, by definition, an illegal arrest or an illegal detention. And an illegal arrest can lead to severe legal consequences. These could include the immediate release of the arrested person by a court, often through a writ of habeas corpus, potential disciplinary action against the arresting officers, the possibility of civil lawsuits against the authorities for damages due to false imprisonment or unlawful detention, and in some cases, even the exclusion of any evidence that was obtained as a direct result of that illegal arrest, the fruit of the poisonous tree doctrine, though its application varies. So, by mandating strict adherence to procedure, Section 62 indirectly ensures that all the specific rights of the arrested person that we've detailed, like those in Sections 36, 38, 47, 48, 49, 58, are respected. It places clear, unavoidable legal accountability on every single police officer, magistrate, or other authority making an arrest to comply meticulously with both the letter and the spirit of the law.
Let's take a final example. If police arrest Mr. G for a clearly non-cognizable offense without obtaining a magistrate's warrant first, which would violate the conditions in Section 35 and the general principles, that arrest is not strictly according to the Sanhita. Or, if they arrest someone lawfully but then hold them in the police station for 48 hours without producing them before a magistrate, violating the 24-hour rule in Section 58, assuming no applicable exception like travel time, the detention becomes illegal after the 24-hour mark. In both cases, Mr. G, or someone on his behalf, could immediately file a habeas corpus petition in the High Court. If the court agrees the arrest or detention was illegal, it would order his immediate release, and the officers involved could potentially face disciplinary inquiries or other consequences. It really is the legal system's ultimate promise. Your liberty is precious and not to be trifled with, and everyone, especially those wielding the power of the state, must operate strictly within clear, established legal boundaries.
That's the fundamental principle Section 62 locks into place for the entire chapter on arrest. Outro.
Wow, what a truly deep dive that was into Chapter 5 of the BNSS, the chapter on arrested persons. We've gone from the foundational powers of police to arrest without a warrant in specific situations, through the limited but real power of citizens' arrest, the direct intervention capabilities of magistrates and courts themselves, covered the unique protections for our armed forces, and then unpacked that intricate web of post-arrest procedures, the rights, the medical checks, the limits on restraint, the search rules, all designed, at least in theory, to protect the individual. It's clear the legal system has a lot to say about how and when someone can be taken into custody. We've really covered the gamut, from ensuring proper medical examinations and access to advocates, right through to that absolute 24-hour limit on initial police attention and the overarching principle of strict legality in Section 62. It's a remarkably comprehensive framework, isn't it?
It really is. And what's truly emerged, I think, is how every single section, every procedure, every right we've discussed today, from those initial grounds for arrests in Section 35 right down to that final command for strict adherence in Section 62, ultimately serves a dual purpose. Yes, enabling the state to apprehend suspects, but fundamentally aiming to uphold the rule of law and safeguard individual liberty against potential overreach or abuse of power. It's a testament, really, to the core idea that power, especially the power to deprive someone of liberty, must always be checked and regulated. It underscores
You've probably
that even
received official-looking mail before, right? Perhaps a jury summons or maybe a notice from some government agency. So it lands in your mailbox, with undeniably serious, maybe you instantly know. This is something you have to
An
respond
arrest
to.
isn't
But if you
just a
ever
single
stop to
isolated
truly think
event.
about
As
what
we've
makes
seen,
that
it's a
piece of
complex
paper so
legal
legally
dance,
binding,
a
what
sequence
gives it the
involving
actual
duties,
power
rights,
to compel you
procedures,
to
and
do something,
responsibilities
like,
for
say,
everyone
appear in
involved,
court?
the police,
And
the arrested
conversely,
person,
what happens when
magistrates,
someone
even
actively
citizens?
tries to
How
disappear,
might a deeper,
to
more
evade the
nuanced
long arm of
understanding
the
of these
law?
provisions,
How does
not
the
just the
justice system
powers,
literally
but
go
also
about
the limitations
making sure people show
and the
up when they're
rights
needed?
empower communities?
Welcome to the Deep
How
Dive,
could it help people
your
better
shortcut
engage
to
with
being
law
well-informed, where we
ensuring that
unravel
both public
complex
safety and
topics into
individual
clear,
justice
actionable
are
insights.
truly served in
Today, we're
practice?
embarking on a deep,
And maybe think about
fascinating
this
journey
too.
into the very
What
heart
other
of how the legal
aspects of
system
our legal
ensures
system,
people
perhaps
fulfill
other
their legal
chapters of the new
obligations with ease.
BNSS or
We're unpacking
related
Chapter
laws
6 of the
you think
Bharatiya
warrant this kind of
Nagrik
deep
Suraksha
dive next?
Sanhita,
Thank you
2023.
so much for joining
You
us
might
for
hear
this
us refer
detailed
to it as the
exploration of arrest
BNSS,
powers and
specifically
procedures
Section
under
63
the
through
BNSS.
93.
We
Now,
really
this isn't
hope you're
just about
leaving
pouring
feeling a little
over
more
like dry
well-informed,
legal
perhaps
text.
a little
It's
more
about
curious,
understanding the
maybe even
intricate
a little more
dance
equipped
between
to judicial
to ask those
authority,
important questions that
personal
help keep our
liberty,
systems
and
fair
the
and
practicalities of law
Until next
enforcement
time,
in
stay
a country
curious
as
and stay
vast and
informed.
dynamic as India. Our mission today is to extract the most important nuggets of knowledge and insight from these foundational legal documents for you, our listener. We've got a packed and truly illuminating deep dive ahead. We'll begin by dissecting the absolute basics: what makes a court order valid, how it's formally served, and what measures the law employs when individuals or even large corporations attempt to evade notice. From there, we'll escalate our discussion to the serious business of arrest warrants, covering who possesses the authority to issue them, who can execute them, and how they seamlessly operate even across state lines. Finally, we'll explore the powerful arsenal the law deploys against absconders, including public proclamations and the attachment of property, and how India cooperates with nations across the globe to ensure justice, no matter where someone attempts to hide. This isn't just a discussion for legal professionals or those in law enforcement. This deep dive touches on fundamental aspects of your rights, the inherent power of the state, and the intricate mechanisms that underpin public order and due process. Understanding these procedures offers you a clearer picture of how the justice system functions, ensures due process, and actively works to prevent evasion. You'll gain a deeper appreciation for the safeguards thoughtfully built into the system and the sheer ingenuity required to navigate complex situations, from a missing witness to an international fugitive. Okay, let's unpack this.
That's a truly excellent setup, because what we're about to explore is nothing less than the very foundation of how the legal system maintains its authority and ensures accountability. Without these foundational mechanisms for compelling appearance, the entire edifice of justice, from initial investigations and inquiries to full-blown trials, would simply collapse into disarray. It's about ensuring that court orders have genuine teeth.
Absolutely. And the BNSS, as India's new criminal procedure code, really modernizes and, in some cases, enhances these critical aspects. So let's jump right into part 1. The foundations of compelling appearance, summons issuance, and basic service. We're started with Section 63, which is all about the form of summons, what makes a summons legally valid. This is the very first step, establishing strict mandatory rules for its format. It's about much more than just a piece of paper. It's a formal, legally binding directive from the court.
Indeed. What's particularly striking here is the prescriptive language of the section. It repeatedly uses the phrase "shall be," which, in legal terms, leaves no room for discretion. These are mandatory requirements for a valid summons. This applies universally to every summons issued under the BNSS, whether it's for an accused person, a crucial witness, or even just to compel the production of a document. This ensures a consistent standard across all criminal courts, from the highest sessions courts down to judicial and executive magistrates.
So no shortcuts, no exceptions. One of the first mandatory requirements is that it must be in writing. It seems obvious, but what chaos would we truly see if a mere phone call or a verbal instruction was sufficient?
Oh, it would be absolute chaos. Imagine the endless disputes about what was said, who said it, or whether it was even said at all. Writing ensures a clear, unambiguous record. It creates an undeniable, verifiable paper trail, which is paramount for preventing future challenges and ensuring transparency in the judicial process.
And here's a detail that really struck me. It must be in duplicate. 2 identical copies. That strikes me as a very specific procedural detail. What's the practical or perhaps even strategic reason behind that?
The duplicate requirement is a brilliant built-in accountability mechanism. One copy is for the recipient, right? But the other is designed to be returned to the court with proof of service, often signed by the recipient themselves. This returned copy immediately becomes part of the official court record, a crucial piece of evidence if the person later claims they never received the summons. It's a simple, yet highly effective way to prevent evasion and provide irrefutable documentation of notice.
That makes perfect sense. It's not just about the content, but the undeniable proof of delivery. Then we have the authorized signature. It must be signed by the presiding officer, that's the judge or magistrate, or by another officer specifically designated by the High Court.
Right, and this point deftly balances direct judicial authority with administrative efficiency. The presiding officer is, of course, the direct source of the judicial decision. However, the High Court's power to designate other officers, like a chief clerk or registrar, is a very smart administrative move. It offloads routine tasks, you see. It allows judges to focus on their core judicial duties and decision-making while still maintaining proper oversight through formal rules. This provides essential flexibility in what can be a very busy legal system, preventing judicial bottlenecks that could otherwise slow down justice.
And finally, that little detail that actually carries immense weight, the court seal. This isn't just decorative, is it? It's the ultimate mark of authenticity and authority.
You're absolutely right. Without that official seal, the document fundamentally loses its official weight and can easily be challenged as invalid. Think of it as the court's unique, undeniable fingerprint, definitively proving its origin and legitimacy, and lending a crucial solemnity to the judicial process. These formalities might seem like red tape, but they are the bedrock of legal certainty.
So when you see that formal piece of paper complete with all these meticulous details, it's not just bureaucracy. What does this deep attention to detail truly tell us about the foundational nature of judicial power?
It tells us that this seemingly simple piece of paper is the very first, almost invisible line of defense against arbitrary power. This meticulous care transforms a mere request into a non-negotiable command, fundamentally underpinning the state's authority to ensure public order and due process. Without these formalities, the entire system would crumble into endless disputes over authenticity and receipt, leading to chaos. A summons that fails any of these criteria is simply invalid, meaning the recipient is not legally obliged to appear, potentially derailing the entire legal process.
That's a powerful consequence for seemingly small details. Let's make this real with an illustration. Imagine Mr. Rahul Sharma, a crucial witness, is summoned by a chief judicial magistrate, a CJM, to testify in a theft case.
Okay. For Mr. Sharma's summons to be legally valid and compel his appearance, it must be on official court letterhead, issued in duplicate, clearly signed by the CJM himself, or a properly designated officer if the High Court has such a rule, and crucially, stamped with the court's official seal. If it were just a phone call, or if it lacked any of these essential elements, Mr. Sharma would be legally off the hook. This vividly highlights the immense practical power embedded in these formality rules.
So once you have a valid summons created, how does the law ensure that crucial first step of actual delivery? That brings us to Section 64, outlining the summons how serve, the gold standard of service. This is the primary method for getting a summons to an individual with a strong focus on direct, personal delivery.
This is indeed the gold standard. Ordinarily, service is performed by a police officer, a court official, or another designated public servant. These are professionals trained to follow proper procedure. The law explicitly states that if practicable, the summons must be served personally on the summoned person. This is considered the most reliable way to ensure they unequivocally receive actual notice.
And the proof. How do they ensure the person actually got it and prevent them from later claiming ignorance?
Well, the serving officer hands one duplicate copy of the summons to the person. The absolutely crucial part is that the person must then sign a receipt on the back of the other duplicate, the one that gets returned to court. This signed receipt is concrete, undeniable proof of service. If the person refuses to sign or simply cannot be found, the serving officer must make an endorsement, basically a written note, on the duplicate stating this fact, which then becomes a formal record for the court.
So why is this emphasis on personal service so key? What's the biggest benefit?
It maximizes the chance that the person is genuinely aware of their obligation. More importantly, the signed acknowledgement provides concrete, irrefutable proof. Without it, the court would struggle to prove the person actually knew, which becomes critical if a warrant needs to be issued later for non-appearance. It also places a clear duty of accountability on the serving officer, preventing shortcuts.
Okay, picture Mr. Anand, summoned as a witness. A police constable serves him, hands him one copy, and Mr. Anand signs the other. Simple, clear, legally sound. But what about when the summoned party isn't a flesh and blood person? How do you serve an entity that isn't physical? That's the challenge addressed by Section 65. Service of summons on corporate bodies, firms, and societies. How to serve a legal person.
Yeah, the section is absolutely essential because legal entities like companies or societies can also be involved in criminal proceedings, either as accused parties or as sources of information. The law specifies that service can be effected by serving it on a director, manager, secretary, or any other authorized officer of the company in India. This ensures the summons reaches someone with actual authority and responsibility within the organization, rather than just, say, any random employee.
Right, so no, just leaving it with the intern or the janitor. What if personal service on one of these authorized officers isn't practical, or maybe they're hard to track down?
That's where an equally valid alternative method comes into play. Registered post. Sending the summons by registered post, specifically addressed to one of those authorized officers, creates an official dispatch and delivery record through the Postal Service. This is a very convenient and verifiable alternative, especially for larger organizations.
And here's an interesting legal fiction that really helps prevent entities from, playing games and avoiding notice. The deemed service clause.
Oh, this is a powerful and very clever legal tool against evasive tactics. If a summons is sent by registered post, service is deemed to have been effected when the letter would arrive in the ordinary course of post, irrespective of whether it was actually collected or not. This means a company cannot simply refuse to collect registered mail and then claim ignorance of the summons. The law legally presumes delivery after that ordinary course period. The section also clarifies terms, defining company broadly to mean anybody, corporate, and corporation as an incorporated company, ensuring no ambiguity in its application.
That's a vital part of making sure justice can't be sidestepped. Why is this section so essential then?
It's vital because it recognizes the legal personhood of these entities, providing practical, workable methods for organizations to be formally notified. But critically, the deemed service clause actively combats evasion. Imagine a large corporation trying to stall proceedings indefinitely by simply avoiding receipt of all official mail. This clause effectively shuts down such strategies and clearly makes specific officers responsible for ensuring their organization handles legal communications.
Let's run through an example for ABC Private Limited to make it concrete.
Okay, consider scenario 1. A court official physically hands a summons directly to the managing director of ABC PVT Ltd at their corporate office. This is perfectly valid personal service. Clear cut. Now, scenario 2. A summons is sent to ABC's company secretary via registered post on May 15th. In the ordinary course, it would typically arrive by, say, May 18th. Even if the letter is eventually returned to the court on May 20th marked refused or unclaimed, service is legally deemed to have occurred on May 18th. The company, in the eyes of the law, cannot credibly claim they didn't know.
So the law has robust ways to reach those who would try to avoid it. But what if the person literally cannot be found for personal service? That brings us to Section 66. Service when person summoned cannot be found, substitute service. This outlines the first alternative when direct personal service isn't possible.
Yes, and it comes with a crucial precondition. The serving officer must first have exercised due diligence to find the person personally. They can't just go to the house once, not find them, and immediately serve a family member. Reasonable, documented efforts must be shown to the court.
Okay, and if, despite that due diligence, they still can't find the person?
Well, if the person cannot be found, the summons can be left with any adult male member of his family residing with him. This ensures a reliable channel, as an adult family member living in the same household is legally presumed to convey the notice. And crucially, that family member receiving the summons must also sign a receipt on the back of the duplicate, providing proof of this substitute service.
So it's a practical, common-sense solution. The law presumes that if served in this manner, the summoned person has received knowledge. Give us a quick illustration.
Sure. Imagine Mr. B is temporarily away from his usual residence, maybe on a short business trip, and the police officer, after making diligent inquiries, cannot find him. But his adult brother, who resides with him in the same house, is home. The officer can legally serve the summons to the brother, who signs the acknowledgement. This counts as valid service on Mr. B under the law.
That's a good first step, a reasonable presumption. But what if even that fails? What if no one is home, or the person is truly elusive? Section 67. Procedure when service cannot be effected as before provided the last resort. Substituted service via affixation. This sounds like the ultimate fallback mechanism.
It absolutely is the ultimate fallback. This section strongly emphasizes that service cannot be effected by the exercise of due diligence, using any of the prior methods outlined in Section 64, 65, or 66. The serving officer must provide a detailed, convincing report to the court of all the genuine failed attempts they made. This is not a shortcut. It's a measure of last resort.
And the actual physical act of affixation, how is that done? Sticking it on the door.
Pretty much. One duplicate copy of the summons is physically affixed to a conspicuous part of the house or homestead in which the person summoned ordinarily resides. This means somewhere easily visible, maybe the main entrance door or a prominent wall. The phrase ordinarily resides is important. It ensures it's their actual, usual home, not just some temporary spot.
So the court just accepts that as service then, simply because it's stuck on the door. Seems a bit easy.
Not at all. This is where a critical layer of judicial oversight comes in. The court doesn't automatically accept this as valid service. It has a mandatory duty to make its own inquiries, meticulously examining the officer's report and potentially questioning the officer under oath to verify the diligent attempts and proper affixation. This is a crucial safeguard against abuse. Based on its inquiry, the court can make one of two determinations. Either declare it duly served, which creates a legal fiction that the person is now legally considered to have received notice, even if they never physically saw it, or, if not satisfied, order a completely fresh attempt at service, perhaps even by a different method.
So the court is essentially saying, look, we did everything in our power to tell you, and this is the last step before more serious action. Why is Section 67 so necessary in the overall scheme then?
It's vital because it prevents individuals from deliberately sabotaging the justice system by simply making themselves unavailable and unreachable. The court's mandatory inquiry prevents any arbitrary or careless use of this less direct method. And critically, once service is declared duly served by the court, it empowers the court to move forward, even to issuing an arrest warrant, because the fundamental legal requirement of notice has now been rigorously met, albeit through substitute means.
A good illustration would be Mr. C, who is clearly trying to evade service, right?
Exactly. Let's say a police officer, after days of diligent efforts, meticulously documenting each attempt, tries personal service and service on a family member for Mr. C, all to no avail. Finally, the officer affixes the summons to Mr. C's front door and reports back to the court with a detailed account. After its thorough inquiry, the court is satisfied that all due diligence was exercised and declares service duly served. Now, if Mr. C doesn't appear on the specified date, the court can legally issue an arrest warrant against him because in the eyes of the law, he has been properly notified.
Okay, we've covered the basics of summons and their various modes of service, from personal delivery to the last resort of affixation. Let's move into Part 2. Special cases and interjurisdictional summons reaching beyond the obvious. This is where we see how the law smartly adapts to specific circumstances. Starting with Section 68. Service of summons on public servants respecting official channels.
This section streamlines the process for serving a summons on public servants. That means government employees, police officers, judges, you name it, by routing it through the head of their office. It's a pragmatic approach that acknowledges their official capacity and the structured nature of their employment.
So the court doesn't just send it directly to, say, a teacher's home address or a police officer's residence.
Ordinarily, no. The court issuing the summons will ordinarily send it in duplicate to the head of the office where that public servant is employed. This is the standard preferred method, recognizing the chain of command. The head of that office then becomes legally obligated to, first, cause the summons to be served personally on the public servant, following the same Section 64 procedures, including obtaining an acknowledgement, and second, return the duplicate copy to the court with their signature and an official endorsement confirming the service.
What are the key benefits of this particular method? It sounds like it might add a layer of bureaucracy.
Actually, it's often about efficiency and respect. It provides immense administrative convenience, avoids disruption to official duties, and ensures respect for the official hierarchy. It's often much more efficient than an outside officer trying to track down a public servant within a large government department, you know. Plus, the head of the office is best placed to ensure the summons reaches its intended recipient, and their endorsement provides strong, credible, and official proof of service to the court. It's also a professional courtesy to the public service.
An excellent example would be Mr. Rakesh, who works as a government teacher.
Right. If a court needs to summon Mr. Rakesh, the summons would typically go to his principal, the head of his office. The principal would then ensure personal service on Mr. Rakesh and, after obtaining his signature, return the endorsed duplicate to the court. It's a formal, efficient, and respectful process that minimizes disruption.
Moving on, what happens when the person summoned lives outside the local geographical limits of the court that issued the summons? That's addressed by Section 69, Service of Summons Outside Local Limits, Bridging Jurisdictional Divides.
This section is crucial for ensuring efficient cooperation between different judicial jurisdictions within India. When the person summoned resides or is found outside its local jurisdiction, meaning beyond the issuing court's geographical area, the issuing court ordinarily sends the summons, in duplicate, to a magistrate within whose local jurisdiction the person resides or is to be found.
So it's essentially a handover between courts in different areas, like passing the baton.
Precisely. That receiving magistrate is then responsible for causing the summons to be served in their local area, strictly following the Section 64 procedures, and then returning the endorsed duplicate to the originating court as proof of service. This streamlined process prevents logistical nightmares and ensures the law can effectively reach across districts or even states without undue friction. It also saves time and resources by leveraging local magistrates and their staff who are familiar with their specific area, and the endorsed duplicate provides clear official proof of service to the issuing court.
So if a magistrate in District A needs to summon Mr. S who lives in District B, how does it play out simply?
The summons is formally sent to the magistrate in District B, who then arranges for service on Mr. S in their jurisdiction. Once served, the proof is returned to District A. It's a seamless and efficient handover, ensuring justice isn't hampered by administrative boundaries.
Now, this next section is where things get truly modern and intriguing. Section 70. Proof of service in such cases, and when serving officer not present, modernizing evidence of service. This defines how to prove service, especially in interjurisdictional cases or when the serving officer can't be physically present in court, and critically, it introduces electronic means of proof. This sounds big.
Oh, this is a significant leap forward, aligning the legal system with technological advancements. It covers two main scenarios. When a summons is served outside the issuing court's local jurisdiction, as per Section 69, and more broadly, when the serving officer is not present at the court hearing. Traditionally, in these scenarios, the court can accept two forms of proof without the officer's physical presence. An affidavit of service, which is basically a sworn, detailed statement by the serving officer, or the endorsed duplicate copy of the summons that was signed by the recipient. Making these admissible in evidence saves immense time and resources, preventing officers from having to travel long distances simply to state they served a document.
But the electronic means part, that really sounds like a potential game changer for efficiency. Tell me more.
It absolutely is. Subsection 2 states that proof of service may also be tendered by electronic means as specified by the High Court. Think about the possibilities here. This could mean scanned copies of signed acknowledgments, digitally time-stamped records, maybe even GPS data of the service location, or other verifiable electronic records. The High Court is empowered to issue rules detailing exactly what electronic methods are acceptable, ensuring security, integrity, and reliability. This aligns perfectly with the digital push of the BNSS and promises faster, more efficient, and potentially more auditable proof of service, making the entire process much smoother in our interconnected world.
So if the High Court specifies that, say, scanned copies of signed acknowledgments and GPS coordinates uploaded to a secure portal are valid, an officer could serve a summons, immediately upload these details, and that would be sufficient proof in court without the officer needing to physically appear. That truly modernizes and streamlines the process.
It really does. It not only reduces the burden of travel for officers, but also significantly speeds up judicial processes and leverages technology for greater accuracy and record keeping, enhancing the overall efficiency of justice delivery.
All right, what happens when all these diligent efforts to serve a summons, even with modern tools and interjurisdictional cooperation, still fail or are simply ignored? That brings us to part 3. Escalation to arrest warrants when summons fail. This is a pivotal transition. Section 71, procedure where summons not obeyed, from directive to coercion.
Exactly. This section outlines the critical juncture where the legal system moves from a non-coercive request, the summons, to a coercive measure, an arrest warrant. The court must be satisfied that two conditions are met. First, the person failed to appear as required by the summons, and second, no reasonable excuse has been offered for such failure. Simply saying, "I forgot," won't cut it. A genuine justification, like a medical certificate for illness, is needed. If both conditions are met, the court may issue a warrant for their arrest, giving the court's directives the necessary teeth.
So a summons can't just be ignored without consequence. Fair enough. But can a court ever skip the summons altogether and go straight to issuing an arrest warrant right from the start?
Yes, it can, and this is an important discretionary power. The court can sometimes issue an arrest warrant immediately, that is, in the first instance, without a prior summons if it is satisfied that the person has absconded or will not obey a summons. This is a careful judgment call made by the court, often based on the person's past history, maybe police intelligence reports, or the inherent nature and seriousness of the case. This power is crucial for preventing deliberate evasion from the outset, particularly with serious offenders who are known flight risks.
That makes a lot of sense for serious cases, where delaying could be detrimental. But what about for minor offenses? Is there a safeguard against arbitrary immediate arrest for something petty?
Absolutely. There's a crucial safeguard embedded in a proviso to this section. For offenses triable by a judicial magistrate of the second class, which typically involve minor offenses, a warrant shall not be issued in the first instance unless the court has recorded its reasons in writing. This provision is designed to prevent arbitrary arrests for petty infractions and ensures a judicial application of mind. Arrest should genuinely be a last resort for minor issues, and the court must provide compelling justification, such as a documented history of the person repeatedly absconding from prior summonses.
Let's illustrate this with a few scenarios to make it clear. First, Mr. D, who simply ignores his summons.
Okay. Mr. D receives a summons to appear, but he doesn't show up on the specified date and offers no valid excuse for his absence. The court, having satisfied the conditions, then issues an arrest warrant for him. Simple as that. Now, for the scenario where a warrant is issued immediately for a serious offense, let's say Mr. E is accused of a serious, non-bailable offense, perhaps something like aggravated assault. Police intelligence indicates he's actively planning to flee the country and has a known history of evading the law. In such a situation, the court can issue an arrest warrant immediately, without first issuing a summons to prevent his escape. Finally, for that safeguard for minor offenses, consider Mr. F accused of petty shoplifting, which is typically a minor offense. However, police reports show he has previously evaded summonses in 5 other similar cases. The judicial magistrate of the second class can issue a first instance warrant here, but only if the court records its specific reasons in writing, such as, accused has a history of non-appearance in 5 previous summons cases, indicating a clear intent to evade justice. This transparency is key to upholding due process for minor infractions.
So, when a warrant is duly issued, who has the legal authority to actually make the arrest? That takes us to part 4. Executing arrest warrants who, when, where. Let's begin with section 72. Warrant to whom directed who can arrest you.
Right. This section specifies precisely who a court can legally authorize to execute an arrest warrant, allowing for a degree of practical flexibility. Ordinarily, and most commonly, a warrant is directed to 1 or more police officers. They are the primary agents of law enforcement, trained and equipped for arrests, making them the default choice for such duties.
But there's a surprising twist here, isn't there? An exception where it can be directed to any other person, perhaps even a civilian. That sounds unusual.
Yes, and this is a crucial and often surprising exception. If immediate execution is necessary and no police officer is immediately available, the court may direct the warrant to any other person or persons. This is a pragmatic solution designed for urgent situations, maybe in remote areas where police presence is sparse, or when existing police resources are critically stretched. It ensures that a crucial arrest isn't delayed by logistical constraints. However, this power is used very cautiously by courts, as it empowers a civilian with significant authority. And if directed, that person shall execute the warrant, meaning they have a legal obligation to do so.
And if a warrant is directed to multiple officers or persons, how does that work? Do they all have to act together as a team?
Not necessarily. If a warrant is directed to multiple officers or persons, it can be executed by all of them collectively, or by any one or more of them individually. This provision streamlines operations, avoiding coordination delays in situations where multiple individuals might be tasked with the same objective.
An incredible illustration of this flexibility is the potential role of the village headman in a remote area, as you mentioned.
Exactly. Imagine a remote village where an urgent warrant is issued for a particularly violent offender. The nearest police station might be hours away. In such a scenario, the magistrate, recognizing the immediate threat and the urgency, could legally direct the village headman, a respected local civilian authority, to execute the warrant. The headman would then be legally obligated to make that arrest. This showcases the remarkable flexibility and practicality built into the system for specific, urgent scenarios where conventional resources are not immediately available.
That's a powerful delegation of authority for urgent situations. Now, let's consider Section 73. Warrant may be directed to any person targeting elusive offenders. This section expands the power of a magistrate even further,
beyond just the issue of immediate police availability, right?
It does. This section specifically grants authority to a magistrate, either a chief judicial magistrate, CJM, or a judicial magistrate of the first class, JMFC, to direct a warrant to any person, even a civilian, when the individual to be arrested falls into certain specific difficult categories. This power is invoked when the person is a proclaimed offender, meaning someone publicly declared by a court as evading arrest for serious crimes, an absconder in a non-bailable offense, or someone actively evading arrest for a serious crime.
So this isn't just about whether a police officer is immediately available. This is about specifically targeting someone who is particularly difficult to find or maybe dangerous.
Precisely. This power is designed for those specific, challenging cases where the accused is known to be elusive or presents a significant flight risk. The directed person shall execute the warrant if the named person is found in the specified place. It's a targeted power for senior magistrates to cast a wider net, leveraging assistance from beyond conventional law enforcement to apprehend particularly elusive or dangerous individuals. It's about bringing every available resource to bear under judicial direction.
A great illustration would be Mr. Z, a murder suspect who has gone into hiding.
Okay. Let's say Mr. Z is an absconding murder suspect, and a JMFC receives a credible tip that he's holed up at a specific secluded farmhouse. Given the gravity of the crime and Mr. Z's evasiveness, the JMFC can direct a warrant to a local, influential citizen like Mr. X, who might have a strong network or intimate knowledge of that area, to arrest Mr. Z if found there. This emphasizes the potential for citizen participation in grave cases, but always under strict judicial direction and oversight.
And once a warrant is issued and directed, how long does it actually remain valid? Does it have an expiry date like some other legal notices? That brings us to Section 74. Warrant directed to police officer warrants don't expire.
This is a truly crucial and often misunderstood detail. An arrest warrant directed to a police officer, once legitimately issued by a court, remains in force until it is either formally executed or expressly canceled by the very court that issued it. It does not automatically expire simply due to the passage of time. This indefinite lifespan is highly practical and necessary for dealing with absconding criminals who might evade capture for years or even decades.
Wow. So if a warrant is issued today, it could still be perfectly valid and enforceable 5-10 years from now.
Yeah, absolutely. Its lifespan is indefinite. This provides ongoing authority to the police and ensures that justice can eventually catch up with fugitives no matter how long they manage to evade capture. Moreover, while a warrant is typically directed to a specific officer, the section allows for flexibility in execution. It can be executed by any other police officer whose name is endorsed thereon, or if the primary officer isn't available, by any other police officer competent to execute it, for instance, another officer from the same police station. This prevents delays due to personnel changes or the unavailability of a single officer. Crucially, only the court that issued the warrant has the power to cancel it, maintaining strict judicial control over its validity.
So if Mr. B absconds for years after a warrant is issued against him in 2024, and he's finally located and apprehended in 2027, that 2024 warrant is still valid and can be used to arrest him, that's a really important distinction from many other time-bound legal instruments.
It is indeed. It's a testament to the long arm of the law and its enduring commitment to bringing individuals to justice, regardless of how much time has passed.
Once someone is arrested under a warrant, they have a fundamental right to know why they're being arrested, don't they? That's precisely what Section 75. Notification of substance of warrant. Your right to know why you're arrested addresses.
This section mandates a critical level of transparency. The police officer, or any other person executing the warrant, shall notify the arrested person about the substance, the key details of the warrant. This means clearly stating who is being arrested for what specific offense and by whose legal authority the arrest is being made. And if the arrested person so requests, the officer shall show him the warrant. This is a crucial right. While a physical copy isn't necessarily handed over immediately, the actual physical document must be displayed upon request.
This sounds like a cornerstone right of individual liberty. It's fundamental.
It absolutely is. This right directly stems from constitutional protections, such as Article 22(1) in India, which ensures that no one is arrested blindly or arbitrarily. It provides immediate transparency at the moment of apprehension, ensures the accountability of the arresting officer, and serves as a vital safeguard against false or arbitrary arrests.
So if Officer P arrests Mr. D, Officer P must immediately tell Mr. D the substance of his arrest, for example. Mr. D, you're being arrested by order of the magistrate for the offense of criminal breach of trust related to XYZ company.
Mm-hmm.
And if Mr. D then asks to see the physical warrant, Officer P is legally obligated to show it to him. This is a fundamental safeguard for individual liberty.
Precisely. It's about embedding due process and transparency at the very first point of contact with the justice system, ensuring that an individual understands the basis of their deprivation of liberty.
And speaking of due process, there's a very strict rule about how quickly an arrested person, particularly under a warrant, must be brought before a judicial authority. That's Section 76. Person arrested to be brought before court without delay, the 24-hour rule.
Yes, this section reiterates a non-negotiable principle of justice. Anyone arrested under a warrant must be brought before the competent court without any unnecessary delay. And to make unnecessary delay concretely clear, there's a strict 24-hour limit exclusive of travel time unless further judicial detention, known as remand, is explicitly authorized by a magistrate.
So without unnecessary delay isn't just a vague term. It has a very specific hard limit, 24 hours plus travel.
Yes, it's absolutely a hard limit. The proviso explicitly states that such delay shall not, in any case, exceed 24 hours exclusive of the time necessary for the journey from the place of arrest to the magistrate's court. This detail about excluding travel time is key. The clock effectively stops for the duration of the journey from the point of arrest to the court. Any detention beyond this 24-hour period without a magistrate's order for further custody is considered illegal. This serves as a critical protection against unlawful, prolonged detention by law enforcement. Once the person is produced before the court, the magistrate can then, if it thinks fit, order further detention, either police custody or judicial custody as deemed proper, ensuring ongoing judicial oversight of their liberty.
This truly is a cornerstone of individual liberty and due process. It echoes constitutional guarantees.
It is indeed. This section directly implements Article 22(2) of the Indian Constitution, which applies broadly to all arrests, not just those under a warrant. It prevents the police from holding someone indefinitely without judicial review and ensures that a magistrate quickly assesses the legality of the arrest and the necessity for continued custody, thereby safeguarding fundamental rights.
So if Mr. E is arrested in Jaipur at 8 a.m. on a Monday on a warrant issued by a court in Jodhpur, and the journey between Jaipur and Jodhpur takes, say, 4 hours, he must be produced before a magistrate in Jodhpur or a local magistrate with remand powers if the Jodhpur court is closed by 12 p.m. on Tuesday. That strict deadline, 24 hours plus 4 hours travel, is absolutely vital.
It's an unyielding deadline that highlights the law's commitment to preventing arbitrary detention and ensuring swift judicial scrutiny of an arrest.
Now let's expand this further and explore Part 5. Interdistrict and interstate warrant execution justice knows no boundaries. How do arrest warrants operate when someone crosses geographical lines within India? We'll start with Section 77. Warrant directed to police officer for execution outside district, endorsement for local authority.
Right. This section meticulously outlines the process for executing an arrest warrant in a different district within the same state. Typically, it requires an endorsement by senior local authorities for its legality and proper execution. The court that issues the warrant usually sends it to the superintendent of police, SP, or the district magistrate, DM, of the destination district, that is, the district where the arrest needs to be made. This senior officer then endorses their name on the warrant, which formally validates it for execution by any police officer operating within their district.
So it's about establishing local administrative control and legitimizing the arrest for the police operating in that specific area, making sure the local cops know what's happening.
Exactly. It ensures that local law enforcement leadership is fully aware of and approves the operation within their jurisdiction. But there is a crucial exception for urgency. The police officer to whom the warrant is originally directed can execute it without such prior endorsement if they have reason to believe that the delay occasioned by obtaining the endorsement would prevent the execution of the warrant.
That's a necessary power for real-world situations, isn't it?
Yeah.
But one that must be used with significant caution, I imagine, to avoid overreach or confusion.
Indeed. This power is to be used judiciously, requiring the officer to genuinely believe that waiting for the formal endorsement would undoubtedly lead to the absconder's escape. It's an essential provision for hot pursuit situations or when credible, time-sensitive intelligence dictates immediate action. The officer would still be accountable for their decision to act without prior endorsement, of course.
So if a police officer from District A is pursuing Mr. Y, a minor accused, into District B within the same state, and Mr. Y is suddenly spotted entering a building, the officer can make the arrest immediately in District B without prior endorsement if waiting would clearly allow him to escape. However, they would still be obligated to report the arrest and the circumstances to the local police and magistrate in District B afterward.
That's correct. It represents a vital balance between the administrative need for protocol and the practical, urgent need to apprehend a criminal.
The complexities multiply significantly when we talk about crossing state lines, though. That's Section 78. Warrant directed to police officer for execution outside state lines. The complexities of crossing state lines. This section deals with the highest level of interjurisdictional execution, a warrant issued by a court in one state needing to be executed in another state or union territory. This must get complicated.
Oh, it involves a more formal and multi-layered process, meticulously designed to ensure seamless interstate legal cooperation while respecting each state's judicial authority. The issuing court ordinarily sends the warrant to the Chief Metropolitan Magistrate, CMM, or Chief Judicial Magistrate, CJM, of the district in the other state where the warrant is to be executed. This ensures a senior judicial figure in the receiving state formally reviews and endorses the warrant, thereby making it valid and enforceable for their local police.
That sounds like a lot of steps and potentially a lot of time. What if there's an emergency and speed is absolutely critical? Can they bypass that?
The law prudently accounts for such exigencies with two important provisos. Proviso 1. If the issuing court itself believes that sending the warrant via the CMM or CJM in the other state will cause a fatal delay, meaning it will critically undermine the chances of execution, it can direct the warrant directly to any police officer for execution outside the state. However, and this is a crucial safeguard, even then the police officer must, before executing the warrant, present it for endorsement to the local CMM or CJM in the executing state. This is a critical check to ensure the receiving state's judiciary is aware and approves of the action.
Okay, so even in urgency, there's still a check. But then there's an even more extreme urgency clause, I understand, for situations where there's literally no time to get that local endorsement, like seconds count.
Precisely. That's Proviso 2. If there is absolutely no time to obtain even a preliminary endorsement from the local CMM-CJM, for instance, a fugitive is on the verge of boarding an international flight and fleeing the country, the police officer may execute the warrant without prior endorsement. This is for truly exceptional, immediate threats. However, immediately after the arrest, the officer must inform the nearest CMM or CJM in the area of arrest about the apprehension and, crucially, the compelling circumstances that necessitated this urgent pre-endorsement action. This ensures immediate judicial review of the officer's critical decision to act without prior local judicial approval.
This section is incredibly detailed and seems to anticipate every possible scenario. It has to, I suppose.
It absolutely needs to be. This level of detail is essential for effective law enforcement in a federal structure like India with its diverse states. It incorporates multi-layered safeguards protecting against arbitrary arrests across state lines, while simultaneously balancing the urgent need for action with fundamental due process. It carefully respects the judicial authority and sovereignty of the executing state, making cooperation viable and legally sound.
Let's run through an illustration, a high-stakes one. Mumbai court issues a warrant for a high-profile criminal, Mr. Q Intelligence, indicates he's about to flee India from Delhi airport. How would these three scenarios play out in practice?
Okay. In a standard scenario, the Mumbai court would send the warrant to the Delhi CMM, who would endorse it, and then the Delhi police would execute the arrest. Straightforward. In an urgent scenario, Proviso 1, if the Mumbai court fears fatal delay, it could send the warrant directly to a police officer tracking Mr. Q in Delhi. This officer must then obtain endorsement from the Delhi CMM before arresting Mr. Q. Finally, in an extreme urgency scenario, Proviso 2, if that officer spots Mr. Q literally boarding a flight with absolutely no time for a CMM endorsement, the officer can make the arrest immediately. But, critically, they must report to the nearest Delhi CMM or CJM immediately after the arrest, fully explaining the urgent circumstances. This illustrates the practical challenges and the careful legal tightropes officers walk, ensuring that even in the most extreme cases, judicial oversight is eventually and swiftly applied.
So once someone is arrested, especially across jurisdictions, what happens next? Are they immediately transported back to the issuing court? Or are there other options, like local release? That's Section 79. Procedure on arrest of person against whom warrant issued local release or remote transfer.
This section details precisely what happens when an arrested person, particularly under an interjurisdictional warrant, is brought before a magistrate. The arrested person is first brought before the local CJM-CMM, or JMFC, of the area where the arrest was made. That local magistrate first confirms that the arrested person is indeed the individual named in the warrant. If their identity is confirmed, the default directive is to order their removal in custody to the court that originally issued the warrant.
But there are specific provisions for bail at this stage, right? Depending on the nature of the offense. They don't always have to be shipped back immediately?
Yes, absolutely. There are two important provisos regarding bail. Proviso 1. If the offense for which the warrant was issued is bailable, meaning the law itself allows for bail as a right, and the arrested person is prepared to furnish bail to the satisfaction of the local magistrate, then the magistrate shall take bail from them and forward the bail bond to the issuing court. This is a practical and humane provision as it avoids unnecessary, costly transfers over long distances for minor offenses when the person can be released locally.
And for more serious, non-bailable offenses, is there any flexibility? Can they get bail locally?
Yes, there is, but with stricter conditions and higher judicial authority. Proviso 2. For non-bailable offenses, the local CJM, or CMM, not a JMFC, this needs a more senior magistrate, has significant discretionary power. They can still order the removal of the person to the issuing court, or, if they are satisfied that there are sufficient reasons for so doing, they can release the person on bail or their own personal bond, subject to appropriate conditions.
Sufficient reasons sounds like it could cover a lot. What might constitute such reasons in this context, like serious illness?
Exactly. Sufficient reasons implies compelling grounds that are carefully evaluated, such as extreme hardship for the arrested person, maybe a serious illness that makes transfer dangerous, or other factors that genuinely outweigh the immediate need for transfer. This provision represents a delicate balancing act, aiming to ensure prompt delivery to the issuing court while also respecting the arrested person's right to liberty and considering practical humanitarian hardships.
Let's use Mr. A, arrested in Kanpur on a warrant from Lucknow, to illustrate.
Okay. Scenario 1. Bailable offense, local bail. If Mr. A has a bailable warrant from Lucknow and is arrested in Kanpur, the Kanpur JMFC would confirm his identity, take appropriate bail from him, and forward the bond to the Lucknow court. Mr. A would then be released in Kanpur, avoiding unnecessary travel. Simple. Scenario 2. Non-bailable offense, local bail for sufficient reasons. If Mr. B has a non-bailable warrant from Bengaluru but is arrested in Chennai, and his lawyer provides compelling medical evidence that an immediate transfer to Bengaluru would gravely jeopardize his life, the Chennai CJM, if satisfied with these reasons, could release him on bail in Chennai, with strict conditions naturally, forwarding the bond to Bengaluru. This highlights the humane flexibility built into the system to address genuine distress.
And what about the local magistrate's precise role in all this? Are they reevaluating the whole case? Section 80? Procedure by magistrate before whom person arrested is brought, the local magistrate's limited role.
No, this section clarifies and reinforces the specific, limited role of the local magistrate when a person arrested on a warrant from another court is produced before them. The magistrate's primary duty is quite focused to confirm that the arrested person is the person intended by the court which issued the warrant, basically, verifying their identity and then, once confirmed, direct their removal in custody to such court.
So they do not conduct a trial or a full inquiry into the underlying offense itself. They just check ID and facilitate transfer, mostly.
Correct. Their role is expressly stated as subject to the provisions of Section 79 as to bail. This confirms that while their primary duty is identity verification and transfer, they can still grant bail under the specific circumstances outlined in Section 79. Beyond that, the local magistrate's role is confined solely to identity verification and facilitating the transfer or granting bail if appropriate. This prevents any duplication of judicial proceedings, streamlines the process, and ensures that the court with original jurisdiction ultimately handles the merits of the case.
So if Mr. C is arrested in District Y on a warrant that originated from District X, the JMFC in District Y would simply verify Mr. C's identity and order his transfer to District X, unless the specific conditions for local bail under Section 79 are met.
Exactly. It's a clear division of labor designed for efficiency and to ensure that cases are heard by the appropriate jurisdiction while still safeguarding the arrested individual's rights.
We've seen how courts use summons and warrants to compel appearance. But what happens when someone truly goes to ground, deliberately avoiding all efforts to contact or apprehend them? That leads us to Part 6. Dealing with absconder's proclamation and property attachment. This is where things get truly serious, starting with Section 81. Proclamation for person absconding, the public declaration.
Yes, this section introduces a very powerful legal weapon against absconding individuals, those who are deliberately avoiding arrest and the judicial process. It allows a court to issue a public proclamation, which is a significant escalation, threatening property attachment if they don't appear within a specified time frame. It's a public naming and shaming, essentially.
What are the specific triggers for a court to issue such a proclamation? It can't just be because they missed one court date, surely.
No, definitely not. The process begins after an arrest warrant has first been issued. The court must then have reason to believe that the person has absconded or is concealing himself, specifically so that the warrant cannot be executed. This requires a clear judicial application of mind, not just a suspicion. Once satisfied, the court publishes a formal written proclamation demanding the person appear at a specified place and time, giving them not less than 30 days' notice from the date of its publication.
So it's a very public warning. But how does the law ensure it's truly public and reaches the widest possible audience? How do they make sure the person really knows?
Good question. To ensure wide notice and prevent later claims of ignorance, the proclamation must be published in multiple mandatory ways. It has to be affixed to a conspicuous part of the absconder's last known house or homestead. It must be affixed to a conspicuous part of the courthouse itself. It must be published in a daily newspaper that is circulated in the area where the absconder ordinarily resides. And importantly, the High Court can specify any other effective method which modernizes the process to allow for new media like perhaps digital publications or online notices. The court's written statement that the proclamation was duly published on a specific day is considered conclusive evidence of compliance.
And this is where the BNSS introduces a particularly significant change, isn't it? The ability to declare someone a proclaimed offender immediately. That sounds like a big deal.
It is a major enhancement in the new law. For a very long list of serious offenses covering most severe crimes under the Bharatiya Nagrik Sanhita, the BNS, India's new penal code, the court may, after recording its specific reasons, also declare the person a proclaimed offender immediately upon issuing the proclamation. This triggers immediate and significant additional legal consequences. For example, once declared a proclaimed offender, even private citizens can lawfully arrest them under Section 40, and the police can arrest them without a warrant if they have reasonable suspicion of their identity.
And there's a crucial technological aspect to this declaration as well, linking it to wider systems.
Yes, and this is truly modern reform. This declaration of proclaimed offender status must be reported to the Director General or Commissioner of Police and, crucially, entered into the Interoperable Criminal Justice System, ICJS. This digitizes and centrally integrates criminal records across all law enforcement agencies, making it significantly harder for proclaimed offenders to hide and boosting interagency coordination by ensuring information is instantly accessible nationwide. It's a big step towards a networked justice system.
So why is this entire process of proclamation so powerful and effective, especially with these new enhancements?
It serves multiple critical purposes. Firstly, it exerts immense pressure to compel appearance by threatening severe consequences, most notably property attachment, and by publicly labeling the individual as a fugitive. Secondly, the multiple publication methods ensure wide public notice, leaving little room for claims of ignorance. And thirdly, the proclaimed offender status, coupled with ICJS integration, provides law enforcement with far more potent tools and faster information sharing, making it a very powerful deterrent and an effective aid in apprehension.
An illustration of this would be Mr. Q, accused of a heinous crime like murder, who's gone missing.
Right. If Mr. Q is accused of murder, which is a serious offense clearly listed in the proviso, and he successfully evades initial arrest efforts, the court can issue a proclamation. After carefully recording its reasons, the court can immediately declare him a proclaimed offender. This status is then instantly updated in the ICJS, making him a priority target for all law enforcement agencies across the country. This vividly demonstrates the significant legal and practical ramifications of this declaration, turning him into a high-priority, nationally recognized fugitive.
And the next, even more serious step after proclamation is hitting absconders where it truly hurts, their wallet. That's Section 82. Attachment of property, a person absconding, hitting them where it hurts.
Absolutely. This section empowers the court to attach meaning to legally seize the movable and immovable property belonging to a proclaimed absconder if they fail to appear within the specified time frame. This is an incredibly powerful coercive measure, and critically, for serious crimes, it can happen much faster than before under the BNSS.
So when exactly can this attachment order be made? Does the court have to wait the full 30 days of the proclamation period to see if they show up?
Not necessarily. The court can order attachment of any property, movable or immovable or both, belonging to the proclaimed person at any time after the issue of the proclamation, but specifically before the 30-day appearance period specified in the proclamation expires. This means the court doesn't have to wait for the entire 30 days to pass before initiating the attachment process to secure the assets.
And you mentioned it can be even faster for serious crimes. How does that work? Is it simultaneous?
Yes. This is another key update and a significant measure against serious offenders. For the same long list of serious offenses as mentioned in the Section 81.3, provides of crimes like murder, large-scale fraud, drug trafficking, etc., the court may, at the very time of issuing the proclamation, order the immediate attachment of any property belonging to the absconder. This prevents offenders from quickly liquidating, transferring, or hiding their assets once they become aware that a proclamation is imminent. It's a swift, decisive move against grave criminals, ensuring their ill-gotten gains or other assets are secured right away.
How is the actual attachment or seizure of property carried out in practice? Do they just lock the doors?
Well, this section details practical methods for attachment, which can include actual physical seizure of the property, like cars or valuables, appointing a receiver to manage the property, like a house or a running business, prohibiting the delivery of the property to anyone else, or a combination of these methods, depending on the nature of the asset.
What happens if the person eventually shows up within the proclamation period? Do they get their property back? Is there an incentive?
Yes, that's the direct incentive for compliance. If the proclaimed person appears within the time specified in the proclamation, the attached property shall not be sold and shall be immediately restored to him. However, if the person doesn't appear within that time frame, the property then legally vests at the disposal of the state government. Even then, there are safeguards. It cannot be sold until 6 months have elapsed from the date of attachment and until all third-party claims, which we'll discuss next under Section 83, have been fully disposed of. The only exception is perishable property, or property whose value would quickly decay, which can be sold at any time to preserve its value.
So why is this power of attachment so effective in compelling appearance and fighting crime? What makes it work?
It's tremendously effective because, let's face it, the threat of losing one's property is a major motivator for an absconder to appear. It also serves to secure assets that could potentially be used for victim restitution or state forfeiture later on. The ability for swift, simultaneous attachment for grave crimes prevents sophisticated offenders from rapidly stripping their assets. And importantly, the waiting periods and third-party claim mechanisms provide crucial safeguards to protect legitimate property rights against arbitrary seizure.
An example of this would be Mr. R., a fraudster accused of large-scale financial crimes.
Right. If Mr. R is accused of large-scale financial fraud, which is certainly a serious listed offense, and he absconds, the court, at the very moment it issues the proclamation under Section 81, can also issue an order for the immediate attachment of his land, his luxury cars, maybe his shares. This swift action prevents him from selling off these valuable assets while he remains at large, ensuring they are secured for legal proceedings.
It makes complete sense to hit them financially. But what if someone else has a legitimate claim to that attached property, like a spouse or a business partner? The law can't just indiscriminately seize everything belonging to anyone connected. That's what Section 83. Claims and objections to attachment protecting innocent third parties addresses.
This section provides an absolutely vital legal avenue for anyone other than the absconder to claim an interest in attached property. It's a fundamental safeguard, ensuring that punitive measures directed against one person don't unfairly and arbitrarily harm innocent third parties who might have legitimate rights over that property. Such a claim must be filed within 6 months from the date of such attachment, and the grounds must clearly state that the claimant have a legitimate interest. For example, they are a co-owner, they hold a mortgage on the property, or they had a prior legitimate sale agreement, and that their interest is not liable to attachment under Section 82.
And the court investigates these claims thoroughly. They don't just dismiss them.
Oh no, the court that issued the original attachment order shall proceed to investigate the claim or objection. This ensures a fair and impartial hearing for the third party to present their case and evidence. Furthermore, if a claim or objection is disallowed, either in whole or in part by the criminal court, the aggrieved person has a crucial right. They have 1 year from the date of that order to institute a civil suit to formally establish their rights over the property. This provides an additional layer of judicial review, acknowledging the complexity that often surrounds property disputes.
This is a fundamental due process safeguard, then. It protects people who might get caught in the crossfire.
Absolutely. It prevents the state from arbitrarily seizing and selling property that legitimately belongs to someone other than the absconder. It ensures fairness and meticulous judicial scrutiny before irreversible actions concerning property are taken.
A good example would be Mrs. Y, whose house is jointly owned with her absconding husband, Mr. Y.
Yes. If Mr. Y is declared a proclaimed absconder and his house is attached, his wife, Mrs. Y, can file a claim with the court within 6 months, stating that it is jointly owned property. The court would then thoroughly investigate her claim. If it finds her claim valid, her share of the property would be released from attachment. If not, she still has the recourse to file a civil suit within 1 year to legally establish her rights. This highlights the robust safeguards in place for legitimate property rights.
Okay, that covers the attachment and protections for third parties. But what is the final outcome of this whole process? What happens to the property in the end? Section 84. Release, sale, and restoration of attached property, the outcome of attachment.
Right. This section details the final disposition of attached property under various scenarios. Firstly, as a clear incentive, if the proclaimed person appears within the time specified in the proclamation, the attached property is immediately released and restored to him. That's the best outcome for them. Secondly, if a third-party claim or objection under Section 83 is allowed by the court, that specific portion of the property is released from attachment, duly protecting the true owner's rights.
What if the absconder never appears within the proclamation period? Is the property just lost forever?
Well, if the absconder does not appear within the time specified in the proclamation, the property legally vests in the state government. However, remember the safeguard. It cannot be sold until 6 months have passed from the date of attachment and until all Section 83 claims from third parties are fully resolved. Again, the only exception is for perishable property or property whose value would quickly decay, which can be sold at any time to prevent loss of value.
And there's the fascinating, very fair provision for restoration, even if someone appears much later, correct? Even after 2 years.
Yes, this is a very important provision for fairness and justice, a kind of safety net. Restoration on subsequent appearance within 2 years. If, within 2 years of the date of attachment, the person, 1, appears voluntarily or is arrested, 2, and proves to the court's satisfaction that they did not abscond or conceal themselves with the deliberate intent to avoid the warrant, 3, and further proves they had no notice of the proclamation in time to appear. Then the property itself, or the net proceeds if it has already been sold, shall be restored to them after deducting any costs incurred by the attachment process.
That's a crucial safeguard against permanent forfeiture due to genuine ignorance or maybe unforeseen circumstances, like being stranded somewhere.
It absolutely is. This provision acknowledges that sometimes people are genuinely unaware or incapacitated due to circumstances outside their control. It provides a vital safety net against permanent forfeiture of property due to an honest lack of notice, thus carefully balancing the coercive power of the state with the principles of justice and individual rights.
For example, if Mr. E absconded in 2024 and his property was attached and sold in 2025, in early 2026, he is finally arrested. If he can convincingly prove to the court that he was genuinely living in a remote foreign country with no access to communication and was truly unaware of the proclamation, the net proceeds of the sale of his property, after deducting costs, will be restored to him as he appeared by arrest within the 2-year window and proved genuine lack of knowledge.
It beautifully demonstrates the nuanced and just approach built into the system, ensuring that even under severe legal measures, there are provisions for fairness and mitigating genuine hardship.
Let's move to Part 7, Flexibility in Compelling Appearance and Evidence. This section highlights how courts can tailor their approach to compel appearance based on the specific circumstances and seriousness of the case. Starting with Section 85. Issue of warrant in lieu of, or in addition to, summons tailoring the coercion.
Right. This section grants courts significant discretionary power to issue an arrest warrant directly, in lieu of a summons, or as an additional measure to a summons. This flexibility is based on factors like the seriousness of the offense and the likelihood of the person's cooperation. It's about being proportionate and effective, not using a sledgehammer to crack a nut,
So a court can actually issue an arrest warrant right from the start instead of bothering with a summons under certain conditions.
Yes, precisely. The court can issue a warrant directly in lieu of a summons, right in the first instance, if, after meticulously recording its reasons in writing, it is satisfied that the person has absconded or will not obey a summons. The requirement for reasons in writing is crucial. It acts as a judicial safeguard, preventing any arbitrary use of this more coercive measure and ensuring proportionality. It intelligently avoids the futile exercise of issuing a summons if there's a high probability of evasion from the outset.
But what about issuing a warrant in addition to a summons? When would that happen? Like doubling down?
Kind of. The court can issue a warrant even if a summons was already issued under specific circumstances. This typically occurs if the person is accused of an offense punishable with imprisonment exceeding 7 years or death or life imprisonment, clearly indicating the gravity of the crime. Or if the person is accused of a non-bailable offense, which by its nature is considered more serious, or if the person has already failed to appear despite being duly summoned and offered no reasonable excuse, as we discussed back under Section 71.
So the law adapts its level of coercion based on the nature of the crime and the behavior of the individual. For example, if Mrs. G is accused of grievous hurt with a dangerous weapon, which is typically a non-bailable offense and can carry a sentence of over 7 years.
In such a case, the magistrate could issue an arrest warrant in lieu of a summons for Mrs. G right from the start, even without specific evidence that she plans to abscond. This decision would be based purely on the gravity and non-bailable nature of the alleged offense, ensuring a swift and appropriate response from the justice system. This clearly shows how the law is designed to adapt the inherent seriousness of the crime.
What if someone is already physically present in court, perhaps as a witness, but their presence will be needed for future dates? The court doesn't want to issue a full summons or warrant just for them to come back next week. That's where Section 86. Power to take bond for appearance, ensuring future presence without arrest, comes in handy, I assume.
Absolutely. This section provides a discretionary and notably less coercive power to the court. It allows the court to accept a bond, essentially a legal promise from someone who is already physically present in court to ensure their future appearance, rather than going through the formal process of issuing an immediate arrest warrant. It applies whenever any person, whether an accused or a witness, for whom the court could issue a summons or warrant, is already in court.
And the court has clear discretion here, right? It's not automatic.
Yes, the court may require this person to execute a bond, which can be either with or without sureties, meaning someone else guaranteeing their appearance, for their attendance in that court or any other court to which the case may be transferred. This is a crucial, less restrictive alternative to an arrest warrant, especially useful for witnesses who aren't accused but whose testimony is vital and needed on multiple dates. It streamlines the process by securing future cooperation without resorting to more formal, time-consuming measures.
So if Mr. I appears in court as a witness today, and his testimony will definitely be needed again on a later date, the court can simply ask Mr. I to execute a personal bond, say for $5,000, promising to appear on the next scheduled date. It's simple, efficient, and respectful of his time.
Exactly. It's a very practical tool for judicial management, ensuring ongoing participation in the legal process with minimal friction and paperwork.
But what happens if that promise is broken? If someone executes a bond and then fails to appear, there have to be consequences. That's Section 87. Arrest on breach of bond for appearance. The consequences of a broken promise.
Yes, this section clearly outlines the direct consequences of breaching a bond for appearance. If a person who executed such a bond, whether under Section 86 or a bail bond, fails to appear at the time and place specifically mentioned in that bond, the presiding officer may issue a warrant for their arrest. Additionally, and importantly, the court may forfeit the bond, meaning the bond amount, which was pledged by the person and/or their sureties, becomes legally recoverable by the state.
So these bonds are definitely not just empty promises. They have real legal teeth. You break the promise, you face arrest and financial penalty.
Not at all empty promises. This ensures that bonds serve their intended purpose. They have significant legal teeth, converting a simple breach of promise into a concrete ground for arrest and a financial consequence. This mechanism is vital for ensuring accountability and upholding the solemnity of judicial undertakings.
For example, if Mr. K executes a bond to appear in court on May 20th, 2025, but then fails to show up without any valid excuse, the court can issue an arrest warrant for Mr. K and concurrently initiate proceedings to forfeit the $10,000 bond he executed, making both him and his sureties liable for that amount.
It clearly reinforces the seriousness of a legal undertaking and the repercussions for noncompliance.
Beyond compelling individuals to appear, courts and police also need to gather physical evidence for their investigations. Documents, objects, things. That's Section 88. Summons to produce document or other thing gathering evidence. This seems fundamental.
Oh, it's absolutely fundamental. It empowers courts and police officers to compel the production of specific documents or things, essentially any physical evidence that are relevant to an investigation, inquiry, or trial. It's a cornerstone evidence-gathering power, really.
Who specifically can issue these orders and for what purpose? Is it just for trials?
A court issues a formal summons for production, while an officer in charge of a police station, often referred to as an SHO, issues a written order reflecting their distinct legal powers. They can do so whenever the production of any document or other thing is necessary or desirable for any stage of criminal proceedings, be it investigation, inquiry, or trial. The necessary or desirable criteria give them broad yet carefully considered discretion. The summons or order specifies that the person in possession of the item must either attend and produce it or to produce it.
And can they just send the document or item without actually showing up in person, if it's just about the object?
Yes, there's a practical flexibility built in. If the requirement is merely to produce a document or thing without requiring the person's testimony or personal presence, the person can comply by simply causing it to be produced, for example, sending it through a messenger or courier instead of attending personally. This streamlines simple evidence gathering, especially for routine documents.
Are there any important limitations or exceptions to this broad power? Can they ask for absolutely anything?
Crucially, no. This section does not apply to certain categories of sensitive or privileged documents. Specifically, it does not apply to privileged documents as outlined in sections 123 or 124 of the Indian Evidence Act, such as state secrets or official communications where public interest dictates their protection. It also doesn't apply to items that are in the custody of postal or telegraph authorities, like sealed letters, telegrams, or parcels. These have their own, often more stringent and specific production rules, reflecting their sensitive or legally protected nature.
So this power is key for broad evidence gathering and efficiency, but it also intelligently protects sensitive information and pre-existing legal privileges. Like if an SHO needs a damaged car part found at a local garage during a hit-and-run investigation.
Exactly. The SHO would issue a written order to the garage owner specifically to produce the damaged part at the police station. This is a common, practical, and efficient use of this evidence-gathering power.
Our journey has taken us through compelling appearance and evidence gathering within India. But in our increasingly interconnected world, crime and witnesses often cross international borders. That brings us to Part 8, International Cooperation for Compelling Appearance and Evidence, the Global Reach of Justice. Let's start with Section 89, Service of Summons or Warrant when person resides outside India reaching across borders. How does that even work?
This section outlines a critical mechanism for how Indian courts can serve a summons or execute a warrant on someone living outside India. An Indian court needing to serve such a document sends it, in duplicate, to a specific officer, court, or authority in that foreign country. The central government of India plays a pivotal role here, officially designating which foreign authorities are to receive such requests through formal notifications. This ensures that requests go through proper, established diplomatic channels.
So it's not a direct communication between, say, an Indian court and a foreign police department. It respects international protocol and sovereignty.
Exactly, it respects foreign sovereignty. The summons or warrant is then served or executed as far as may be possible according to the procedure followed by the court or authority in that country. This ensures it's legally valid and recognized within the foreign jurisdiction. This entire process relies heavily on international good faith, mutual legal assistance treaties, and established diplomatic channels.
So if an Indian court needs to summon a crucial witness who is now living in the United States, it would send the summons to the authority designated by the central government for the U.S., maybe the U.S. Department of Justice. The summons would then be served on the witness according to U.S. law and procedure.
Precisely. It's a formalized pathway to ensure legal processes transcend national boundaries, though its success often depends on the level of cooperation from the foreign country.
What if the court needs testimony from a witness abroad who simply cannot or will not come to India? They need the evidence, but the person won't travel. That's where Section 90, Letter of Request to Competent Authority in a Country or Place Outside India, international witness testimony becomes crucial.
Yes, this section empowers an Indian court to issue a formal letter of request to a foreign court or authority to examine a witness who is located in that foreign country. This power is particularly vital when a witness's testimony is crucial for the ends of justice. But their attendance in India cannot be procured, perhaps due to illness, inability to travel, or other legitimate reasons.
And this letter of request is a very specific type of formal diplomatic communication, a formal plea for help almost.
You could say that. The Indian court sends this formal letter to a competent court or authority in the foreign country, respectfully asking them to conduct the examination of the witness. This power is absolutely vital for gathering essential evidence from abroad, ensuring that trials in India remain fair, complete, and comprehensive, even when key witnesses are globally dispersed. It represents a formal request for judicial assistance and cooperation between nations, upholding the integrity of the judicial process.
So a key witness in an Indian trial, perhaps a medical professional living in Canada, is willing to testify, but is genuinely unable to travel to India. The Indian court can issue a letter of request to a Canadian court to examine the doctor.
The Canadian court would then record the testimony, often under their own legal procedures, and transmit it back to India.
It ensures that geographical boundaries don't become insurmountable barriers to justice or the pursuit of truth, leveraging international cooperation.
And for documents that are held abroad, is there a similar mechanism? Section 91, summons to witness to produce foreign documentary evidence.
Yes, this section addresses situations where an Indian court requires a specific document that is in the possession or power of a person located outside India. The Indian court issues a summons which may or may not be accompanied by a formal letter of request, depending on the complexity and foreign legal requirements to that person, requiring them to produce the document. This summons is then sent to the central government for official transmission to a court or appropriate authority in the foreign country for action. This facilitates the gathering of crucial documentary evidence from international sources, adhering to established diplomatic and legal channels.
To make all this international cooperation smoother and more predictable, there must be formal, overarching agreements between countries, right? Not just case-by-case requests. That's where Section 92. Reciprocal arrangements for service of summons or warrant, formalizing international aid comes in.
Absolutely. This section empowers the central government of India to proactively enter into formal reciprocal arrangements, essentially treaties or bilateral agreements with foreign countries, specifically for the mutual service of summonses and execution of warrants. Reciprocal is key here. It means each country agrees to help the other in these legal processes, ensuring a two-way street of cooperation. This establishment of formal frameworks creates a streamlined, predictable system, vastly improving the efficiency and cooperation in cross-border cases, benefiting both nations involved.
So an example would be if India and the United Kingdom enter into a treaty for mutual legal assistance. That formal reciprocal arrangement would then govern precisely how summonses and warrants originating from India are handled and executed in the UK, and vice versa, providing a clear and reliable roadmap for legal cooperation.
Exactly. It replaces ad hoc requests with a structured, reliable system essential for global justice in an interconnected world.
And finally, a particularly critical tool against transnational crime, which often involves assets hidden across borders. Section 93. Reciprocal arrangements for attachment and forfeiture of property fighting transnational crime. This sounds really important.
This section is hugely significant in the modern fight against sophisticated, cross-border criminal enterprises. It empowers the central government to establish reciprocal arrangements with foreign countries, specifically for the attachment and forfeiture of criminal property located abroad. Even more powerfully, such arrangements can also include mechanisms for the physical transfer of this property or its proceeds back to India.
So this is about chasing illicit funds and assets wherever criminals try to hide them around the globe, following the money internationally.
Precisely. The scope of property covered is broad. It can include property obtained from a crime, proceeds of a crime, or property that was used in the commission of an offense under the BNSS. This section is an incredibly powerful legal framework for combating sophisticated transnational criminal activities like large-scale financial fraud, drug trafficking, and money laundering, where criminals routinely stash their ill-gotten gains abroad. It allows India to actively pursue, freeze, recover, and bring back criminal assets, demonstrating how its legal frameworks extend to track and seize criminal assets across the globe, ensuring that crime doesn't pay no matter where the money is hidden.
Wow. We've just covered an immense amount of ground in this deep dive, from the essential elements that make a summons legally valid, like the signature and seal, to the intricate web of international cooperation that allows justice to truly reach across borders, chasing fugitives and their assets. We've meticulously seen how the BNSS details procedures for everything from a simple witness summons to the complex process of pursuing an absconding criminal and attaching their property, even if those assets are located in another country.
What truly stands out in this deep dive, I think, is the incredibly careful and deliberate balance the legal system attempts to strike. On one hand, it grants immense power to courts and law enforcement to compel appearance and gather evidence, ensuring that justice can be served and that individuals cannot simply evade their legal obligations without consequence.
And on the other hand, it builds in crucial, undeniable safeguards at every single step. Strict requirements for written records, layers of judicial oversight, the need for explicit legal reasons for coercive actions, fundamental rights for the arrested individual, and robust protections for innocent third parties.
Right.
It's a system designed to be effective and robust, but ideally not arbitrary.
Exactly. Every procedure, every proviso, every seemingly tiny detail within these sections serves a profound purpose to prevent ambiguity, ensure due process, and ultimately uphold the rule of law in a complex society.
As we've seen, every one of these intricate procedures is there for a reason, building a complex but largely resilient system. But what happens when, despite all these detailed provisions, human error inevitably creeps into the process? Or when a truly ingenious absconder manages to find a loophole that the law hasn't yet anticipated? How does our understanding of these detailed, often overlooked legal procedures shape our trust in the justice system and our belief in its ongoing ability to adapt to an ever-changing world and ever-evolving criminal tactics? Something to mull over until our next deep dive.